difficulty.
Next week, my lord, or any day, my lord.
Just for the sake of adjournment, we are not adjourning. Next week, today, first item. Yeah, next.
First attempt.
May it please, Your Lordship. Lordship, with the due consent of the other side, I beg to mention item number 43, 44, and 45. Lordship, in 43, my lord, we have supposed to get an affidavit today, my lord. We'll be filing it by tomorrow, my lord. My lord will have fix it any day, my lord, in the next week, because they'll be filing the reply.
Mr. A. Fukon, Learned Standing Counsel, GAD, commits that an affidavit on behalf of the respondents represented by him would be filed during the course of the day.
My lord, tomorrow. Because today,
Filed on Kali day today. Accordingly, registry to list this matter again
10 days.
after 2 weeks on a date to be fixed by it.
Deeply obliged.
Yes.
Please, Lordship. Item number 54 of daily list, Lordship. Lordship, matter will be kindly adjourned for today, Lordship. Government has not filed affidavit, Lordship.
We'll see why the government is not filing affidavit. Let the matter come up. Why the promotions are not being done? We'll see it when the matter reaches.
May I please, Lordship? Lordship, with the consent of the other side, Lordship, I beg to mention item number 32, Lordship.
32.
32, Lordship. In that, we have received the instruction, Lordship. Kindly grant some time to file our affidavit, Lordship. And for the petition.
Why on the same cause of action, 2 writ petitions? One, there is an order already from this court, madam. Why the second writ petition? Same issue. Where is Mr. Kumar? Where is Pathak?
Mr. Kumar is out of station.
On the prayer of the Learned Counsel for the parties, the registry to list this matter again after 2 weeks. In the meanwhile, the respondents to invariably bring on record their affidavit in opposition.
Lordship, I beg to mention item number 56 of the supplementary list. 56 of the supplementary list.
Yes.
Lordship, the senior is unwell, so he is
Who?
unable.
Who is your
Sir,
senior?
M.K. Sharma.
And why was a memo not circulated? The respondent number 7 is married.
Lordship, I do not have the brief with me.
Yes, pension matters. Why are you adjourning it? A prayer is made on behalf of Mr. M.K. Sharma, Learned Counsel for the petitioner, for an adjournment on the ground that he is indisposed. Prayer is not objected to by the Learned Counsel for the respondents. Accordingly, registry to list this again after 4 weeks on a date to be fixed by. You have taken the consent.
Lordship, I'm not aware. My senior instructed me.
But matter will be called up.
Lordship,
Yes.
fix it at 2. Lordship, may fix the matter at 2.
Whenever it reaches. Yes.
Item 37, my lord. One of them we have.
And without taking a consent, why are you here? Please don't repeat this. Yes.
One of them we went for filing affidavit in opposition, my lord. For respondent by 8.
What is the issue?
My lord, regarding I'm the petitioner, my lord, I have challenged the order passed by the Education Tribunal, my lord. And the petitioner is going to return the 31st of March, my lord.
Yes. What is the error in the order?
There are errors, my lord. There are number of errors, my lord. The government advocate has represented all the department, my lord, department as well as the private respondent. One council representing all. Private respondent, government department, finance department, managing committee, etc., my lord. So there is a possibility.
I should like to file affidavit in opposition. One of them.
When was the order passed by the Learned Tribunal?
My lord, 25. My lord, 26/9/2025.
You are Mr. B.K. Gugoi.
On behalf of BK Gogoi, my lord.
A prayer is made on behalf of the respondent number 8 by the Learned Counsel for the respondent number 8 to grant him a week's time to file an affidavit in the matter. Prayer accepted. Registry to list this matter again on on 16/3/2024. No further time shall be allowed to the respondent number 8 to bring on record his stand by way of filing an affidavit, inasmuch as it is projected that the petitioner is slated to retire from his services on reaching the age of superannuation with effect from 31/3/2026.
Obliged.
May I listen, please? I wish to mention item number 46, madam. So, let's say may not be taken on the camera.
Oh, not by me. It is before any other.
I have taken the consent, madam. Pardon. I have already informed, madam. Deep load.
May I please, your lordship, with consent of other side, I beg to mention item number 17.
Huh?
Item number 17, 17.
1-7.
Adjourn for the day, lordship. Consent of other side.
Wait. Oh, you have circulated a memo yesterday. Memo was circulated by Mr. B. Kaushik. Item number 17. Consent was taken. On the prayer of the learned counsel for the petitioner, not objected to by the learned counsel for the respondent, matter stands adjourned for 4 weeks. Item number 17, huh? Yes.
Hey, please, your lordship.
Hmm.
Lordship, I beg to mention item number 55 of the supplementary list.
Transfer matter.
Transfer matter, lordship, there is some medical emergency.
They have filed an affidavit long back. You've not
I
filed.
have filed a reply.
Then what is more is required?
Nothing is required, lordship. We can go for the final disposal, lordship.
We'll take it up.
Lordship, there is some medical emergency in the family that's
What happened?
mother is not well. She's
Oh. A prayer is made by Mr.
16th, if it can be.
Mr. F. Paridi, learned counsel for the petitioner for an adjournment in the matter on account of pressing personal inconvenience. Prayer is not objected to by the learned counsel for the registry to list this matter again on
16th, if it is convenient.
20-203-2026.
Much. Lordship, interim order passed.
Interim order passed earlier to continue till the next date of the. Hope she is fine.
Yeah, she's fine.
Otherwise, fine.
Yes.
May I please, your lordship? I beg to mention for listing of one WBC, it was supposed to come.
No, I'm not the senior bench. You will have to mention before the senior bench.
Please, your lordship. Lordship, with the consent from the other side, I beg to mention item number 15 and 16. Even this matter, I'll be led by my senior, Mr. D. Das. He is currently out of station on a professional purpose. Lordship, may kindly take this matter up on 20th.
On the prayer of. But what is left here? You have retired, you have gone away.
Lordship, we have just challenged the select list. Petitioner
That and done. After retirement, how will I promote you?
Lordship.
On the prayer of the learned, a prayer is made on behalf of Mr. D. Das, learned senior counsel, appearing for the petitioner for a D. Das.
Yes.
For a adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the respondent. Accordingly, registry to list this matter again. 26-3. 27-3-2026.
Much obliged.
Yes. It will be a number.
I have challenged the advance data pilot. Nil ballot and except D.
What is your right here? What right has been violated?
The petitioner ballot has been
You have
Elected
been
by holding a Gaon Sabha,
recommended.
my lord.
You have been recommended by the Gaon Sabha.
yes, my lord.
Subsequently, the Gaon Sabha, before the matter could be finalized
Yes.
by the authorities, Gaon Sabha withdrew it.
No, my lord.
Withdrew it
Till
means
date-
that it, forget this, it had taken a separate, another resolution.
Yes, my lord.
That is also
After
on
5
record.
days, my lord.
What, they are now proceeding to issue fresh orders.
That by the order dated 7/8/2024, my lord, a new selected ED, my lord, it was ordered that implement should be made, my lord. New selected, my lord.
Oh.
Pursuance of that order. my lord,
We are
we have
vacating
filed
that.
an IA, my lord.
IFO?
IA for implement, my lord.
Okay,
The respond number 8, my lord.
she is not a,
She has been appointed, she has been selected for respond number. New selection, my lord.
no, what right has been? Yes, madam.
Yes, my lord. Her selection was cancelled by the Gaon Sabha, my lord.
Hmm.
She has,
Till
That
date,
has-
that cancellation letter has not been communicated to the petitioner.
You have got it through the affidavit in opposition now?
Yes, my lord.
Then,
I have also replied that, my lord.
See, the reason is that your residence is far away from this
Same
center.
village, same village, my lord.
And where have you said that you are not far away?
The same village, my lord.
No, where? Might be a big village. They thought that this lady would be better. So how can we step into the wisdom of the,
That is why, my lord, by the order dated 7/8/2024, my lord, an order has been issued by passed, my lord, for implement of the new selected, my lord.
forget it. Now we are not interested. We are interested with you only. You show me your right that has been violated.
Implement should, my lord, may be allowed, my lord, and she may be appeared, my lord. Notice should go, my lord, to the respondent.
We are not in a position to, we don't want to, we want your right to be first established. You establish your right, why her? We'll implead anybody who you want. You show me your right.
By holding the Gau Sabha, my lord, the petitioner, my lord. has
The
been
process
selected.
is, it will go to the Gram Sabha.
Gau Sabha.
Gram Sabha will make a
selected the petitioner, my
then
lord.
it will go to the block district.
Yes.
But here, your case did not proceed from the block to the, from the Gram Sabha to the block. So, nothing materialized.
The petitioner's village is Monakosha, my lord.
Hmm?
And kindly see the page number 52, my lord.
You just show me one line wherein you have dealt with the resolution, reason given in the resolution in your reply.
Resolution, my lord. Resolution dated, my lord.
Page 48, resolution number 1.
Today's meeting has taken the resolution to cancel the selection of Pinjira Khatun.
Where is that? Because
That cancellation letter has not been communicated to the
that much
petitioner.
only is your grievance.
No, my lord.
I'll direct them to communicate
No,
that to you.
no, my lord.
Now you tell me that this reason is perverse. Where is your pleading to that effect?
The petitioner is a qualified lady of village.
Oh, forget qualification. Where is that? How have you dealt with that reason?
The petitioner is also a local lady, my lord, of that village, particular village, my lord. And after 5 days of the selection of the petitioner, my lord, news.
You are appearing for the Gaon Sabha. You have also filed an affidavit here.
Yes.
Fahida Khatun. And the second resolution, your cancellation, in between there was another advertisement. Fresh advertisement was issued.
Yes, my lord.
That has been challenged, my
That
lord.
has
in
been
this
challenged.
We're here.
Yeah,
Yeah, my lord. In that second is a advertisement, my lord. The petitioner.
Yes. Why was her cancelled? She is not from your village.
But he is far away from the other.
How big is the village? How far away?
Then half kilometer, my lord.
That's the one, the resolution, the Gau Sabha, my lord.
One, huh? Show me how far she is. Why is she not?
Does not mention how far he is.
Then why this?
Page number 28, my lord.
interlocutory application, IA bracketed C 3592, 2025. The heard Mr. Samgita Likhiwe, A. Chaudhary, Learned Counsel, S. Islam, Learned Counsel for the petition. The present interlocutory application has been instituted by the applicant, who is the writ petitioner in the connected writ petition, being WPC number 1392/2020, for impleading Ajufa Khatun, to me apostrophe Prakiba, as respondent number 8 in the connected writ petition. Also, it is projected in the application that Ajufa Khatun was selected by the Gaon Sabha for appointment as a Asha Karmi after cancellation of the recommendation made in this connection in favor of the applicant by the same very Gaon Sabha by the very same very Gaon Sabha, and the ground assigned for the cancellation is clearly perverse. Full stop. This court has perused the contentions raised in the said interlocutory application and is of the considered view that Ajufa Khatun is a necessary and proper party in the connected writ petition, and accordingly, the present writ petition, present interlocutory application is allowed, permitting the petitioner to implead. What is a full name? Implead. It will page 4. Ajufa Khatun in the connected writ petition in the following manner, followed by apostrophe semicolon as respondent number 8. We go. With the above observations and directions, the present interlocutory application stands disposed of. Writ petition on here. In view of the order passed today in WIC bracketed 3592/2025, impleading the following, impleading A to A, page 4 of River Minding. As respondent number 8, petitioner to file an amended cost title within 2 working days from today. Subpara. On filing of the said amended cost title, petitioner to take steps for service of notice upon the newly impleaded respondent number 8 by way of speed post steps within 2 days from filing of the amended cost title. Also, registry to list this matter again after 4 weeks. Mr. Islam, you must come up with some reasons. That was what I was wanting from you. Yes.
My lord, before your lordships, my lord, take up the proceedings, my lord, I sincerely apologize, my lord. The record has not yet been traced out, my lord. My lord may give us 1 week time, my lord.
Why?
My lord, actually the inquiry was done at Jorhat, my lord, as I am told. And there is the information is given that the file has been misplaced, my lord. Therefore, we need some more time, my lord. Just a week, I will come up with the proceedings, sir. That part, my lord, he was a professional trainee driver when he was faulted with this corrupt practice. Therefore, my lord, he was
How did
released.
you file? If it is in Jorhat, how did your director file this affidavit before this court?
No, my lord, that file was, since he person was, as I'm told.
How did he file it?
Affidavit has been filed, my lord, earlier.
How did he file it without the original file?
My lord, that is what, my lord. Either it may be in Jorhat or maybe because this office of the ASTC has been shifted from Paltan Bazar to Rupnagar. The whole HO has been shifted from here.
Dr. A. Samoha, Learned Standing Council, ASTC, prays that he be granted further 2 weeks' time to trace out the records of the proceedings, department proceedings instituted against the petitioner in the matter. Petitioner, full stop. Prayer accepted. The registry to list this matter again on 27/3/2026.
Before 25th, my lord.
Before 24/3/2026. Also, in the event the records are not placed on the next date of listing, this court would proceed to consider the issues arising in the present writ petition basing on the materials already available on record.
My lord, I'm obliged. Okay.
Yes, allowed.
Already joined.
When are you retiring?
In 2028.
28. Mr. B. Kaushik, Learned, Standing Counsel, Secondary Education Department submits that in terms of the directions passed by this court-wide order dated 19/2/2026, the petitioner has been allowed to resume her services at Chandra Nath Sharma Higher Secondary School. Also, the petitioner is presently continuing, petitioner has also resumed her services. Also, Mr. Kaushik submits that he be granted 2 weeks' time to receive further instructions as to the manner in which the respondent authorities would now proceed with regard to the departmental proceedings instituted against the petitioner. Registry to list this matter again after 2 weeks on a date 2 weeks by. Now work nicely.
Yes, my lord.
Ah.
I am always ready, but
No, you are not ready. You work.
no, my lord. As per my lord, after sexual harassment, they have to follow.
Oh, that is gone. That is
Yes, my-
past. Past.
Okay, now, my lord, I will do. Done
You
with
do your
it.
duty, teach the children nicely.
Yes.
Then we will see what can be done. Okay?
Yes, obliged.
And you also take a call. And when you take a call, have some compassion, see what the grounds are. Lady, she was exposed to such things. So see what can be done. Yes. Yes, granted.
Mr. Asotha will appear in this matter. He's on legs.
You have got your money.
No, Lordship. It is regarding termination from service, Lordship.
Oh.
Yes.
This is item number. Sorry.
For Lordship.
Yes.
Lordship, on the basis of an FIR, Lordship, he was the
What happened to the criminal case?
It is FIR, Lordship. And also, Lordship, he did not have any role to play in the construction works, Lordship, in implementation of the scheme. He was only a Gram Roskar Sahayak, and other accused, Lordship, they are already continuing in their service.
But this is independent of the criminal case.
But Lordship,
But you were not given a notice.
no notice was given.
What we can do at best is,
Lots.
because this is of 2018, we can direct the respondent authorities to treat this as a show cause. You submit your reply. We'll give them a month's time. Let them take a call.
Lordship,
Very serious allegations.
yes, Lord, but Lordship, his termination was based on the basis of this FIR.
No. You
Lordship.
come to page 44. Criminal case is different.
On the-
If you want that, we can do that. Otherwise, it's difficult. With this,
Lordship, he was only a Gram.
no affidavit also fine.
Lordship, no affidavit filed.
Okay, let Mr. Doctor come down. We'll not put it in our mouth.
I have received some instruction, Lordship.
No, instruction you are always receiving.
Lordship,
Money released.
not released because due to mismatch of head of account, Lordship.
It is submitted by the Learned Standing Council Revenue and Disaster Management Department that the proposal as forwarded by the District Commissioner Dima Hassau for authorizing to the petitioner ex gratia amount of rupees 2 lakh, being the next of kin of late Papu Bora, was required to be returned to the District Magistrate Dima Hassau without according sanction, inasmuch as the head of account as noted in the proposal was mismatched with the actual account against which the said proposal was to be submitted. So he submits that the proposal, a rectified proposal on being received from the District Commissioner Dima Hassau, further processing in the matter would be carried out by the authorities in the Revenue and Disaster Management Department. So accordingly, he prays that the matter be taken up after 4 weeks. Prayer accepted. Registry to list this matter again after 4 weeks on a date to be fixed by. The communication dated 5/3/2026 received by Mr. Learned Standing Counsel, Revenue and Disaster Management is kept on record and marked as X for the purpose of identification.
May I please, your lordship? Lordship, petitioner is also already appointed, lordship.
Yes, madam.
May it please your lordship? Engaged counsel is on legs, may the matter pass over.
Legs, call.
Yes.
After some time. Yes, Mr. Das.
May I take your after some time?
Yes, what is your
My lord, I'm sorry, my lord, there is some miscommunication actually on my part. The matter was already fixed today, my lord. I have informed the authority that some misunderstanding that I informed the authority that it is fixed on 13/3 and I sought the instruction for 12/3, my lord. So
on the prayer of Mr. S. Das, registry to list this matter again on 13/3/2026. You are for the college.
Yeah.
That list is the verified final list. Huh? And how can we deny him? You get your instruction on 30.
But
Department.
Huh?
Department is to.
yes, yes.
Then it-
The-
You wanted to bring on record something.
We've already got it, man.
Yes.
Mr. Kyal is on legs, your lordship. Kindly take up the matter after some time.
Now this matter has to be taken up for final disposal.
Yes, ma'am. There are 3 issues. One is removal
Three
from.
cases, 3 different issues. Okay.
Yes, ma'am.
When? Today or some other
Well,
day?
I believe if it's possible to maybe taken up today itself, ma'am.
There is a long list. I'm not sure whether I'll be able to. Okay, we'll see at 2.
Ma'am.
Obliged.
May please your lordship, the petitioner was termination from his service lordship. The
Yes.
Anganwadi
Lordship,
worker.
we have received a prayer summons here, Lordship. He was serving as a voluntary, he's giving voluntary service there, Lordship. Upon receiving some public complaints, Lordship. And
Is there any interim direction?
No, Lord.
So what happened to that post? Somebody else is working.
No instruction, lordship. Lordship, the showcase notice to showcase notice, the petitioner replied to showcase notice, then the termination. Lordship. The first showcase notice, lordship, page 18, lordship.
Yes, who is working? Somebody is working in that post.
Lordship, that instruction I have to get, Lordship. Because
You have got your paradise.
parents comments I have got, basically in connection to him, Lordship. Whether
Okay, that is fine. When are you filing the affidavit?
let's say at the earliest, Lordship.
No, the earliest means when?
Within 2 weeks' time, Lordship.
2000.
Mr.
Very
C.K.S. Urva, learned counsel appearing state counsel appearing for the respondents submits that the affidavit on behalf of the respondents represented by him would be filed without fail on or before 23/2026. No further time shall be granted to the respondents to bring on record their stand by way of filing an affidavit. The registry to list this matter again on 33/22. 33, 2020 plus.
May I please, Your Lordship? Your Lordship, in this matter, Your Lordship, the petitioner has challenged the very punishment order, which is at Annexure H, Your Lordship, stoppage of 4 annual service increment with cumulative effect by order dated 11/5/2007. Here, Your Lordship, the primary contentions that I have raised in this petition is the very issue of proportionality and the impugn order being a single wrong, which has the effect of continuing damage or continuing wrong till the retirement of my service, Your Lordship. So those are the primary grounds that I have taken
Very good
under.
grounds.
Yes,
Very
Your
good grounds. But first tell me
Yes,
the
Your
delay.
Yes, Your Lordship. That is the only particular issue that I have taken, Your Lordship. May I just submit a judgment?
There are decisions of the Supreme Court which says
Yes, Your Lordship.
inordinate delay.
Yes.
Here it is more than inordinate delay.
Yes, Your Lordship. Here, which I'm placing a judgment of this Honorable Supreme Court, Your Lordship, there was an inordinate delay with respect to preferring a writ petition after 30.
Sorry, this is not the proposition. Tarsem Singh is not the proposition.
Yes, Your Lordship. The only aspect that I am harping upon, Your Lordship, is the continuing wrong, Your Lordship.
No, your penalty you suffered, you thereafter was promoted. So the penalty has lost its force.
Yes.
And after the delay,
yes, Your Lordship,
we are not entertaining your writ petition.
But Your Lordship, you
satisfy me that the delay is, you have explained the delay. I have not even explained.
Yes,
delay
Your Lordship, because
after 2015. Till 2015, you were repeatedly submitting appeals. Repeated appeals submission is also not a ground for extension of.
Yes, Your Lordship. Your Lordship, the only one aspect that I'm also focusing on this instant case, Your Lordship, is the continuing wrong, Your Lordship.
Sir, there is no continuing wrong here. There is no continuing wrong here, Mr. Daka. There is no continuing wrong. The punishment imposed, the wrong happened, if according to you.
Yes.
It does not continue. It is there. It's not pension. It's
yes,
a penalty. It's
yes.
an order.
Yes, Your Lordship.
Ah.
There's also a particular distinction with respect, as Your Lordship is well aware, with cumulative effect, which perpetuates the wrong.
We are not concerned with that because this is a wrong which happened on a particular day.
Yes, Your Lordship.
And it is from that day the limitation starts.
Yes, Your Lordship.
And here there is no question of a recurring limitation.
Yes, that is a continuing wrong, Your Lordship, because what the Honorable Apex Court has held that with cumulative effect.
This is with cumulative effect. I'm sorry. A penalty is a penalty.
Yes, Your Lordship. May I just submit, Your Lordship, one of the judgments which has distinguished between without cumulative effect and with cumulative effect, which perpetuates the wrong, Your Lordship.
We are not concerned with that.
Yes, Your
We are not concerned with that because this is an order of 2007.
Your Lordship.
And you have instituted this writ petition.
In the year 2023, Your Lordship.
So
those were the particular grounds.
You have not even brought on record any explanation to that.
Yes, Your Lordship, because I have.
Where is that Rajasthan case?
Otherwise, delay, Your Lordship. I've forgot. Just in fact, few weeks before, Your Lordship, I placed that judgment and now I forgot. I just have to look into it.
Yesterday I forgot. I was going through. I just forgot this. Okay. Anything more?
Your Lordship may kindly consider these two judgments as a submissions, Your Lordship.
Which two judgments?
Tarsem Singh and one of the judgments, Your Lordship. Because, Your Lordship, that aspect is that which perpetuates.
Show me that penalty has also been held here to be a continuing. Show me that.
Any penalty, Your Lordship?
Huh?
Your Lordship, the wrong which I have.
It's not a wrong.
Yes.
You have to prove it to be a wrong.
Yes, Your Lordship. Since I did not have the particular inquiry report with me,
Not-
Your Lordship.
not
I did not
convincing.
annexed, Your Lordship. But the continuing.
This is a case proposition for a continuing,
Yes, Your Lordship.
and yours is not a continuing.
It is, Your Lordship.
No,
May I just?
first we'll have to see
Yes,
whether
sir.
that penalty was proportionate or not.
Yes,
If
that
we
is not
come to the
proportionate. Your Lordship.
question that it is not proportionate,
Yes,
then everything will fall.
Yes,
But
Your-
why should I go into after 17 years? Why should I go into that after 17 years?
yes, Your Lordship, because Your
Yes,
Lordship,
then that is the end of the matter.
because proportionate, Your Lordship, is with the fact that I had unauthorizedly. was
Mr.
with me for
Dekka,
28
Mr.
days, Your Lordship.
Dekka, the penalty is to be understood in the context of the charges. Right? For examining that, your delay is in the way, and we are
Yes,
not
Your Lordship.
examining.
Continuing, Your Lordship may record my submissions, Your Lordship.
That we will do naturally.
And one of the judgments may I also place in. Otherwise, Your Lordship, only those are the particular grounds that I have taken, Your Lordship, continuing wrong, which I. could
You
find.
get that judgment for me.
Yes, Your Lordship. Your Lordship, tomorrow, Your Lordship, because today I have some personal difficulty. Tomorrow, Your Lordship,
Tomorrow.
Your Lordship.
And 28 days of unauthorized leave, Your Lordship, that is also one aspect that which has become.
But learned counsel for the parties
Yes,
have
sir.
come in. Hearing remains inconclusive. Registry to list this matter again on Monday.
Yes, Your Lordship.
Tomorrow again,
Monday.
they'll have to prepare a list, come back.
Yes, Your Lordship.
May I
I'm
please, Your Lordship?
dismissing it.
Monday, I have certain difficulties.
You need
Maybe on
not be, I'm
Tuesday, Your
only for
Lordship.
passing the order.
Tuesday, Your Lordship,
Tuesday,
Monday,
Your
I also have a difficulty.
Okay, Tuesday.
Tuesday, Your Lordship.
If I be allowed to substantiate any further arguments, may I? Your
Naturally.
Lordship? Much obliged, Your Lordship.
Sincere apologies, Your Lordship, I'm interrupting. With regard to item number 8 to 10, Your Lordship, prior information had been received, Your Lordship, that matter has been fixed at 2 already in court number 4, a tribunal matter, Your Lordship. So if possible, item numbers 8 to 10, Your Lordship, it was fixed at 2 earlier. We were just informed that
We'll have it at 12.
12. Obliged, Your Lordship.
Lordship, this is the instruction. And in terms of this instruction, Lordship, yesterday also we have received the instruction from the Sarva Shiksha Vision that how he was working in both the institution together. So Lordship, with that report, now the department will verify, and Lordship, I pray that at least 2 weeks or time may be granted.
Forward.
For that verification will be required because the SSA that Lordship.
That is what we gave you time last time.
Yes, in terms of this notice, in 21 February 26, this letter. In terms of this letter, yesterday only he has forwarded all these documents that we sought for. So now how he was working in 2 institutions.
That is apparent from here. What further inquiry do you want?
Lordship.
That is apparent.
No. He is saying that he was also working in the college as well as in the Lordship school, which is at 75 kilometers away from the college, Lordship. How a person, he can manage both the institutions together, Lordship. Whereas it is not possible, permissible and not possible, Lordship. So we call for the Lordship, all the documents from the mission director, that what was his appointment, how he was working, what is his attendance register, everything. So yesterday evening we got this. Now, Lordship, the department will, the directorate will verify those, Lordship. For that, I am seeing that.
Mr. A.R. Tabil, Standing Counsel.
Since 24, my lord, this matter
Okay.
is pending, my lord.
Yes, Mr. Sharma. You argue. Now, first tell me.
Yes.
Did you accept this appointment at page 17?
Yes.
State pool teacher.
Yes.
Did you accept this appointment?
Yes.
Then if you have accepted this, how are you continuing in the college?
My lord, that lien is there, my lord.
Lien
Yes,
will not be there. In a private college,
Yes.
where is the concept of lien?
It may be in so many words. It may be
No,
lien or
I'm
the
sorry,
permission.
Mr. Sharma, lien is in respect of a government servant.
That is, my lord, permission may be taken. It may
No.
be taken.
I'm sorry.
And then
This is a fresh appointment. You have joined here.
I have joined, but my lord, that if the.
And you have suppressed that fact before the authorities.
No, we have
Yes.
not separate.
Show me
Yes.
that you have disclosed.
Yes.
Where have you said that?
No, we have mentioned in my writ petition, my lord.
Forget your writ petition. Show me a permission granted to that effect.
My lord, in that letter may kindly be looked upon, my lord. Page 37. For a period of 3 years, I took permission from that authority, my lord.
Show me that lien is permissible
My
in a
lord,
private institution.
not the specific that word lien is there, my lord. It may be a simple request of permission, my lord.
No.
And
The
that was,
requirement under the Provincialization Act is
yes,
the continuous nature of service.
but
That is missing in your case.
yes, that is, my lord, if that provision is seen, my lord, it must have completed, rendered at least 6 years continuous, as on 1/1/17, from the date of joining in the concerned venue, educational institution, which must be on 31/12/10, my lord. So I joined it 2008.
No, on 18, you don't have a continuous service.
But I joined it 2008.
Fine, maybe, but you don't have a continuous service as on 2018.
My lord, since 17, my lord, I was there, my lord.
Maybe, but you are not there because you have got a government job now.
No, I left
How
it.
can you be working as a state pool teacher and at the same time work in a venture school?
My lord, I left it in 17, my lord.
Left it in 17?
Yes.
Rules require till 18 continuous service.
But it is, no. It is 17, my lord. That rules is there, my lord.
Rule?
Rule 3, my lord.
2017. 4-3. 4-3.
4-3.
Okay. We accept this. We accept this.
Yes.
But on the date your case was considered,
Yes.
you were not in this college.
No, I was in the college, my lord. I was in the college, my lord.
See, this letter at page 34 denotes that you are not there. Sorry, that letter you just showed me?
Yes.
Page 37.
37.
So on the date your case was considered for provincialization, you are not there.
It was on 9/9/17.
You are not there. Thereafter, the case was considered.
That date is, my lord, 1/1/17.
Be that as it may, when you are not there, why should your case be considered?
My lord, what is written there, that I have the honor to state that.
And see, you have resigned from your state pool teacher appointment only in 2020. So from 17 to 20, you are there.
Yes, in 20 I was there. But in the similar situation, my lord, another candidate who left on 21, my lord, and he was accommodated.
We don't have the concept of negative equality.
It's a clear case of discrimination.
No, this is a case of negative. We can't accept negative equality.
My lord, that is also
I'm sorry.
He was on 21, my lord. He left it.
I'm sorry.
And the governing body, they asked the report from the governing body. Governing body has said that.
How are you working? Show me. When you yourself are saying that I'll not be there for 3 years.
My lord, it may be taken on Monday, my lord. I will show it, my lord. Today I wanted that they will file this report.
That is what they were trying for, but you were saying it's from 24, so I wanted to hear you.
I'm submitting that a short time may be given, my lord.
In the Lordship page 41 also, in the governing body's Lordship resolution, it is stated he suppressed.
Mr. A.R. Tabilda, Learned Council for the Learned Standing Council, Higher Education Department submits that further time till 23/3/2026 be granted to the respondents to complete the inquiry to ascertain the working status of the petitioner in 2 different institutions during the period 2017 to 2020. So prayer accepted, registry to list this matter again on 30/3/2023. No further time shall be granted to the respondents for the purpose.
And my lord, the report should be submitted by affidavit so that we should also get the opportunity.
We will give you the copy. Don't worry about it. Without giving you a copy, we will not proceed in the matter.
Obliged, Lordship.
Yes, why was she released?
May it please, Lord. Lordship, this letter has been forwarded to us today.
He is still continuing in his service, Joint Director, Health
Yes.
Services.
Yes, Lordship.
Why? He is not in a condition, why is he continuing then? These are all frivolous exceptions you are taking. Yes, madam.
My senior lacks in another.
Show me that your appointment is a regular appointment.
Senior is having the brief.
Huh?
My senior is having the brief. He lacks in another.
Huh?
My senior having the brief, Lordship.
Oh. After some time.
Like.
Yeah, Lordship. So actually, on the last occasion, government was asked to bring some instruction or to file affidavit.
Okay, first you satisfy that you belong to a pensionable establishment.
So actually, they were initially under minor irrigation department.
That's it. Whether minor irrigation corporation, it's not a department, it's a corporation. It's a pensionable department. I'm sorry, it's not a pensionable department. The VRS benefits that have been given, that's why you got VRS benefits. Otherwise, you would have got the other benefits.
Similar situated somewhere given, Lordship.
No pension has been given to anybody. And you have accepted that. And you have filed this writ petition in 24.
Yes.
Whereas the benefits were given to you in 2005. You're dismissing this. Anything more?
Let it be Mr. Fuyad's presence.
No. You are more than enough. Anything is there, tell me.
Let it come, Lordship. He's in legs, Lordship.
Okay. After some.
Right, Mr. Lawson.
Yes, Mr. Ras.
May I be permitted to reframe my
Withdraw.
prayer? Reframe my prayer, my lord. Instead of the mandamus, my lord, that a direction be issued to the authorities to dispose of the matter according to law.
You want to withdraw this?
No.
Or you want me to pause that? Yes, who is appearing for the education department?
Instead of mandamus, my lord, let a direction be issued to the authorities.
Get somebody. Elementary education. Elementary. Mr. Das, just wait for some time. Let somebody come. I'm also proposing to do that only because they have undertaken that your case was not considered because your case was not placed before the district. We'll ask them to place that.
Let them do it according to law. That matter is pending for a long time.
Raised it to list this matter before any other bench without me.
Petitioner was disqualified during.
Have you alleged malafide against the doctors of
No.
the
No, my lord.
force?
Malafide is not alleged, but.
And how do we know that you were the person who was before the Kokrajhar Medical College? No photos, nothing?
So usual medical records.
No. This is a serious issue.
My lord.
We'll have to be satisfied that it was you who was there. It could be anybody.
But in the affidavit, the respondent didn't raise this question.
I'm raising it.
Okay.
Order I'll have to pass.
Yeah. Is my name, father name, address there.
That anybody, I can also go and stand there saying I'm UN Chetri. Can't I? Maybe the color may create a problem. Otherwise, it's same. Yes, who is for the respondents?
But similar. Yes.
Who is the CGC? S. Burua. Get hold of Miss S. Burua. Timing.
Here, Mr. Lawson.
How is postdoctoral research to be considered for the your promotions?
My lord, as per UGC regulation 18, my lord.
But UGC has filed an affidavit saying that if that is not along with the teaching thing, it will not be construed. What do you have? You have not filed an affidavit.
My promotion is granted after, my lord, implementation of this UGC regulation by the university authority, my lord.
Fine, they
And
found that
that-
mistake subsequently. You had a postdoctoral research
Yes.
period.
Yes.
That was to be excluded. They had excluded that. And subsequently from 2018, they have given it back to you.
No, my lord, yes, already, my lord, they have already granted promotion to the similarly situated person from 16. Now, their question is that since the act is come into effect on 18, so my promotion will be granted from 18. Now, I am claiming from 17 because 17 I have joined the university, my lord. If this is applied, this rule regulation is may apply, then my post service of, my lord, 4 years, if that is counted, my lord, I am entitled for, my lord, from the date of my eligibility, my lord. Now they are saying,
Date of eligibility is the date of joining.
my lord. So, my lord, in the promotion has been
Show me
granted.
the UGC regulation. Who is appearing for the respondents? You are appearing. Tezpur University.
Yes, Lordship.
You are there. Okay. Where is the UGC regulation?
My lord, I have already quoted in my petition, my lord.
Where?
My lord, page 13, from page 12, my lord. Page 13, my lord, last paragraph. Clause 10 above the UGC regulation 18 state as follows. The previous ad hoc or temporary or contractual service, by whatever nomenclature it may be called, shall be counted for direct recruitment and for promotion, provided that the essential qualification of the post
That
has-
is what I am saying, Mr. Singha. This is with regard to service as a teacher, not as a research scholar. The subtle difference is there. You come to the affidavit of the UGC.
My lord, yes.
Page 78, para 9. So,
My lord, 10, my lord, if Lordship may kindly go through 10, my lord. Nor it is said it should be, my lord, for teachers only. My lord, kindly see page 14.
Page
14, my lord.
there cannot be another interpretation here, Mr.
Yes, my lord. And my lord, this,
Yes, wait.
my lord, kindly 14, my lord, see. The essential qualification of the post.
No. Previous ad hoc, temporary or contractual service.
Service, sir. My lord, now,
Service. This is for the purpose that you had an ad hoc service, a non-sanctioned post working, but you were in the university system. That period will be, there are decisions on this point of this court only. That period, whether it will be counted for fixation of the period for your senior scale. Then this court had also said that that period will have to be counted. So you will get a boost. 2 years are there. So 2 years will come down from your regular service. But where is the provision for?
then, my lord, I may be allowed to take instruction whether he was serving there or with, my lord.
That should come on record in the.
My lord, let me.
You have said, you have
Yes.
categorically said, it was only postdoctoral research. Come to para 6. Yes, what do you say? What is your case?
Lordship will bring our stand on record by this week. Your Lordship will file
sorry.
affidavit.
Why did you not make that mention earlier?
Lordship, there was some delay in receiving instructions. Lordship.
My lord, already, my lord.
On 21/7, you had taken time on first date is of 4/12/24.
My lord.
23/5/25, 11/6/25, 21/7/25, 2/2/26. Why? Every day you are taking time. We'll ask your authorities to be here, whoever it is. Ask him to come online at 2 p.m. Why the affidavit is not being filed for last around 6-7 days? You have been regularly taking time. The authorities are not giving you instructions.
Lordship, we've received and the affidavit.
No, why so delayed? Small issue. It's not a rocket science here. Then
Yes, Your Lordship.
who is appearing? Who is leading you in this matter?
Mr. K. Alia, Lordship.
Ask him to be here.
Yes, Your Lordship.
Lordship, for a moment, my lord. Kindly see annexure 43.
No, we will see when Mr. Kayal is here.
My lord.
May please, my lord.
When did you retire?
On 39/2024. Appointed as stipendiary teacher in the year 1996, my lord. Then
But
my
your appointment was against excess force. You participated in the screening process.
Yes, my lord.
You accepted the appointment given.
Yes, my lord.
Then
Then my lord, here my lord, one judgment about
Purnima Hore.
Purnima Hore.
Hore will not come here.
I accepted my lord as tutor, my lord.
No. You accepted as a irregular and illegal teacher.
That is my lord. Yes, my lord. That is my lord. But my lord initially appointed as stipendiary.
That was illegal. You accepted that. You participated in the screening process. And then the decision was that you will be appointed prospectively. You accepted that. Now, how can you claim that?
But my lord, I have filed affidavit in reply, my lord. That my lord, one judgment, my lord, Babul Ali, my lord. This is my lord.
Where is your reply? When did you file it?
Yes, my lord. I have filed my lord.
You have received a copy, Mr.
Yes, Lord. 6/11/2025.
11.
It's not on record. Give me a copy.
Therefore, my lord. May I read my.
What is the case number?
Yes, my lord.
6779.
Yes. 8/70/2022.
It's 2012, my lord.
Okay, show me that you were appointed after a selection and against a sanctioned vacant post.
Initially, my lord.
Where is your selection particulars?
Yes, my lord. Appointment letter, my lord. Page 20.
Oh, appointment letter. This is very dicey. This is dicey. Where is the preceding facts of this appointment letter?
Yes, my lord. Hereafter,
When was the advertisement issued? When did you participate in the interview?
that will be to bring my record, my lord. Here.
No, you have not said anything in the writ petition.
yes.
Then that is why you accepted the. Were you receiving salaries?
Yes, to 2012, my lord.
12.
Yes.
And now you have been, you were regularized as teacher.
Sir, my lord. Page 41, my lord.
41.
Page 40, my lord.
Teacher.
Yes.
Rightly so. And this was in 21. You accepted this.
Yes, my lord.
It's only just prior to your retirement that you have now come up. Nothing is there.
So I am accepted, my lord. Regarding acceptance, my lord, there is one judgment of our High Court, my lord.
No, forget acceptance. Show me that that
Selection
initial
process.
appointment was in pursuance to a process of selection.
That is not.
That you were picked up from the road in that 91 to 96 period. Rightly so. Why did you go then before the screening committee? You should not have gone. Should have come here. Have you come here before this? Have you come here earlier? This court then?
I have to take instruction, my lord.
What instruction? 2 o'clock. 2 o'clock.
Your Lordship, we have been newly engaged as counsel in this matter. We have been newly engaged as counsel in this matter, Your Lord. We may be
When were you engaged?
yesterday we received the briefs.
Huh?
We have received the briefs yesterday, Your Lordship.
Yes. I also got this brief at night yesterday.
We've already filed the wakalat number, Your Lordship.
Don't file. Yes, what is your case? Yes, madam.
Lordship, in this matter, petitioner is a drop listed candidate, Lordship.
Drop.
Drop listed candidate, Lordship.
Drop listed candidate.
Yes, Lordship.
I have heard about drop features. Now I am heading drop listed.
Drop list out, Lord. Drop
list out. Okay, fine.
dropped out.
Very good.
Yes.
Then
Drop, Lordship, kindly see,
show me how when there is open dust, I can go beyond open dust.
Lordship, I have read another judgment, Lordship, of Dharam Singh, recent judgment, Lordship.
I am covered by on the issue of
Lordship, kindly
2000
consider length of the period.
on the issue of 2005 regularization, madam, there is a decision of the division bench. I am bound by that.
Yes, Lordship, he is junior or at the
And
same.
you were waiting from 2005 till 2024.
Lordship, kindly see page number 57, Lordship. This is clearly reflected that he is the engaged prior 1993, Lordship.
Fine. But after the Upenda's judgment, how can I?
But Upenda's case is not clear, shows that
See the last paragraph of Upenda's.
drop out the
Anybody.
dropped
No
out this,
regularization in this state.
dropped out candidate, Lordship.
You have Dharam Singh. That is
Lordship,
the latest.
Jaggu, Lordship.
Jaggo.
Jaggu.
Will not do.
There is the
Will not do. Will not do.
Lordship, some time, Lordship.
You will have to give me a judgment of parity. There is a judgment. Parity. That persons who were there were regularized, but you were there in the same bottle, but you were left out.
Lordship, kindly see page number 40. Lordship.
Okay, prepare. Why? Why will he not get? Following the latest Supreme Court decisions, as well as the decision of the Supreme Court, which says that when similarly situated persons have been regularized,
Juniors are also.
the person should not be left out. We'll not give him areas. We'll not give him areas. But pension he will get.
My lord, in Jago's case, there, my lord, the Honorable Supreme Court had noticed that the conditions of their service says were very similar to those under permanent establishment, and they
I'll show you. If that is your ground, argue, I'll deal with it.
Lordship, kindly see please.
Madam, I'll deal with it. You argue. I'll deal with it.
And in Upendas, my lord, there it was.
Upendas, now Supreme Court has come with a different proposition altogether. Binding on me. Jaggo, Haram Singh, and that Tamil Nadu case.
I'll go through the judgment. my lord.
You prepare, get me that judgment on parity. But they'll on a counsel for the parties at some length, registry to list this matter again. Actress on 31/3/2026 for further hearing.
Lordship, that IA is pending, Lordship, for.
Oh, let it be there. If we regularize him, the money has to be paid by you only.
Lordship, her prayer is only for regularization.
Oh, we'll provide the rest.
I live like this.
Who are you?
I am the second
In
wife.
relation to the government employee?
I am the second wife.
Second. And who are you?
I'm the first wife.
Pension is received by the first wife.
Yes, Your Lord, 40%.
What happened to the rest 60%?
My Lord, maybe in the, my Lord.
You are getting.
No. What the fact is, my Lord, when as a second wife, initially we had raised a claim for.
I'm not on that. I'm not on the facts.
The adjudicated
What
position.
happened to the 100% pension? It was to be given
40 first wife, 40 second wife, 20 mother.
mother.
After that order, the authorities issued an order at page 6, giving it to the first wife.
Full pension.
We approached this court. From December 24 onwards, I'm not getting any share. Therefore, I approached this honorable court, saying this is not as per the arrangement.
No, who is retaining that 60%? She says
No. There's
she
an
is
interim
getting
order
only
passed.
40%.
There was an interim order passed in that matter.
Hmm.
In this case, rather, in this case,
Hmm.
where the honorable court says, all right, we'll secure the 40% of the first wife.
Hmm.
So far as your parties will hear the matter. The matter has since been continuing since 25 million. So therefore, it is with the treasury.
No. Who is keeping the balance amount?
What does happen? There's a number where the balance is, the treasury has written to the bank saying that there's a court order and only 40% of the amount of pension has to be released to the first person. Otherwise, what should directs, all 100% can be released to the.
You release 100% to the first wife. First wife will release the share 20% to the mother, 40% to the that. Finished.
Yes, that can be done.
That is to be done.
That is.
Of course, since that is the arrangement, but I must be fair, under the law, second wife does not have a chance.
Mr. Bonik, you will not get the pension. The pension will be the eldest surviving wife, which is the respondent herein. She will draw the pension. In terms of the earlier directions of this court, you will disclose the mother will disclose the, what do you call that, bank account number, her bank account number. You will disclose your bank account number. She will make that transfers every month, 20, 40 and retain 40.
Then, if Lordship takes up at 2, I can give the bank account number straight away. Here it will form a part of the order.
No, that we don't want.
That will be easier. Otherwise, what?
The mother's account number will also
Because
be.
what?
How are you transfer? Mother is also not getting now.
Not getting.
You're not getting. Get your mother's account number also.
At 2.
3. At 3.
At 3.
You get your mother's account number. You get your
Yes.
client's account number. And Mr. Islam,
My Lord.
regular transfer, one complaint, you will be in trouble.
My Lord,
And whatever areas are there, that will also come to your account. Divide it.
My Lord, the ratio was fixed as per the earlier Sirajun Nessa.
40.
Now, my Lord, Junupa Bibi hold the field, my Lord.
Forget Junufa Bibi.
With agreement.
You have agreed. Junufa Bibi only to the extent that you will receive the money. But the ratio, we are not disturbing. You are disputing the ratio.
Now, at present, my Lord, she is disputing, my Lord.
She is disputing.
My Lord.
That 50-50 will not do.
No, my Lord.
100%.
Except mother's share. Mother's share, she is agreeing.
She is not entitled to any share.
No, my Lord.
Now we will stop, Lekha. A dispute has arisen in the matter. A dispute is raised by the learned counsel for the respondent number. We are stopping your pension.
Then
We are stopping your
fixed,
pension.
my lord, fixed at 2, my lord.
No, we are stopping your pension. You have raised a dispute, now we'll have to decide.
My lord,
We'll decide. We are stopping your pension in the meantime. They are also not getting, you will also not get.
Interim order contrary ke disillam.
Okay?
Ekon
Yeah.
disilla. Ab nai nahi.
Mr. M. Islam, learned counsel, should I pass that order?
My lord, at 2, my lord.
Now only, why you two? You are contesting now, we'll hear the matter completely. Till that time,
Then, my lord,
Mr. Chalia, ask your treasury officer to stop everything.
Right now.
Mr. M. Islam, learned counsel, we are stopping it in terms of Junufa BB because you are not
consistently objecting
in
this
terms
way.
of the maybe it's 2, my lord.
you are not agreeable
No,
to
at this stage, my instruction, my lord, she is not agreeing. My lord.
not agreed, then
But-
fine. We'll stop everything. We'll hear.
My lord.
Mr. M. Islam, learned counsel for the petitioner submits that although the petitioner in the earlier, although the respondent number 11 in the earlier round of litigation had consented to have the pension shared between the petitioner, herself and the respondent number 12 in the ratio of 40:40:20. However, she is not presently disputing this at position. This court, when the present writ petition was moved, had directed the respondent authorities only to release 40% of the family pension to the respondent number 11. Also, as a dispute has arisen with regard to the sharing of the pension, the other two eligible beneficiaries not being paid their pension, this court is of the considered view that until further orders, the pension authorized to the respondent number 11 shall remain suspended. The registry to list this matter again after 4 weeks on a date to be fixed by.
No, that is fine. Only one point, my lord. My client is suffering penury. And that
Can't help it because he is
I understand.
raised a
So,
dispute, so we'll decide that.
If with the permission of this court, if I'm thinking aloud, could it be this way?
Short.
From 27 January onwards, we were on the receiving end. We didn't have the money. She's enjoying the money. Now raising a dispute. Let our 40% and as per the now the dispute is coming, be paid.
The money will go to her.
Of
And
course,
she
we are not
is
objecting that.
disputing, so we are not. We are stopping everything. Everybody be in penury.
Well, short date maybe.
Huh? No, we will decide the whole thing now because he is disputing the earlier writ petition. Yes.
Well, short date may be given.
No, after 6 weeks. How can you, Mr. After having undertaken that order, having attained finality, now dispute that position? Where is the position in Junufa? Junufa does not say
No, my
that
lord.
they are not entitled.
They are entitled,
Then-
but the first type is the trustee and my lord.
Only the trustee.
Then they claim my lord maintenance, my lord.
You want her to file a writ petition? Suspend it about 8 weeks. This is not called for, Mr. Islam.
My
This
lord.
is not called for.
Maybe an earlier order.
No. Are you agreeable to receive 100% and share? The order to type out no qualified. We are having it at 3 p.m.
My lord.
Come back with your bank account numbers.
My lord.
40% you retain, 20 mother, 40 second wife. Come back.
My lord.
Or I'll keep this order.
My lord, at 3, my lord.
3, yes, at 3.
Highly obliged, your lordship.
And ask your client to not act smart. We know how to bring her down also.
My lord.
This is not done, mister. You have agreed before this court and you have not taken that order on appeal. Now you rely on Junufa Bibi. Yes.
Highly obliged, your
3
lordship.
o'clock.
Lord, I have the instruction not to press this petition. Petitioner is suffering from cancer, my lord, so he is not interested.
Mr. Purkaisto, yesterday night I was searching for one thing.
My lord.
that policy decision. You have made such bold
Yes, I have,
statements,
my lord, I have.
but the policy decision is nowhere there.
No, my lord, absolutely right.
And the policy decision rather is on the other way around. Then how did your client fight this writ
My
petition?
lord, initially, my lord,
This is misleading this court, wasting
No.
the time of this court.
No, he initially, my lord, he was of the, my lord, he was of the view that there is.
No, he may of the view, whereas the council who had drafted the writ
Counsel,
petition,
I have relied on his statement.
then he is misled us.
So at this
So we'll have to impose some cost on him
and the
for such frivolous petitions being filed.
my lord, kindly appreciate one thing. That initially, my lord, he approved the authority by making application on RTI. RTI authority, my lord, kept the matter pending. Then government advocate was requested whether there is any policy.
There is no such policy.
Exactly. So I have come to the conclusion, I made him to understand that this petition is not maintainable.
So you were also taken for a ride by your client.
This is, my lord, my maybe on mistake on my part.
Not your part. You have been taken a ride on you. That is Mr. Purkaista's greatness. That he is not putting the blame on his client. But your client has misled everybody here.
He is at the moment he is suffering from cancer.
On the Mr. A.K. Purkaista, Learned Counsel for the petitioner, submits that the projection made in the writ petition that of the existence of a government policy notified on 8/4/1988, permitting further 5 years service to a teacher is actually done on a on account of a miscommunication existing in the matter. He submits that the petitioner, having realized the said aspect, has requested him not to press the writ petition any further. So, Mr. A.K. Purkaista accordingly submits that he be permitted to withdraw the present writ petition. Prayer is not objected to by Mr. N.J. Khatonia, Learned Counsel for the Learned Standing Counsel, Elementary Education Department, appearing for the respondents, and Miss I. Datta, R. Datta, Learned Counsel for the respond number 5, and Mr. Fukon, Ms. Fukon for respond number 4. Also, in view of the above, the present writ petition stands dismissed on withdrawal.
The Chowdhury has actually pondered his mistake on my part.
No, not your part. It's on the part of your client. That's what I said. I did not say it's a mistake on the part of Mr. Purkaista. I said it was a miscommunication and the petitioner realized. I'll never put that blame on Mr. Purkaista. Never.
Obliged.
But it took me some digging yesterday with that voluminous petition to find out that policy, because I was very eager to find that policy.
I tried my best. I personally,
I don't understand. It happens.
It happens.
Please, Your Lordship.
Yes.
My lord, petitioner before Your Lordship, he is qualified, my lord, Central Armed Police Force examination and conducted under SSC. In recruitment process, his candidature was considered under EW certificate. But in result, as declared, his candidature is declared under general category. So, petitioner expecting that if his candidature is considered under EW certificate, he would have been appointed in CISF instead of BSF. That is the case. Why his EW certificate was not accepted? Before filing this writ petition, petition was totally in dark. So we are trying to argue that at the time of document verification, if he was informed that his EW certificate was not valid, then it could have rectified. But that opportunity was not provided to the petitioner. So we are trying to argue that this natural justice violation is there, and it is arbitrariness. So we are praying for interference by this honorable court.
But now, after the filing of the affidavit by the respondents, what is the stand?
Now they are to plead that.
Okay, forget everything. This is 226 court. We can have a very broad view of the matter, right? When was the income certificate taken?
Lordship.
income certificate taken, annual income certificate of your father taken.
Yes, sir.
When, which year?
My lord, in affidavit in reply, we annex, that is, my lord, 19/10/2022 issue.
2022.
Yes, my lord.
What is the formula for issuance of a EWS certificate?
Formula, lordship, the following.
Or the criteria? Every year it has to be taken out.
Yes, my lord.
So 2022 income certificate will be for 2022, 23.
22/23, yes, my lord.
It
Financial
cannot
year.
be for 24, 25.
No,
Can it be?
no.
Now come to your EWS certificate in the writ petition.
Yes, my lord. That certificate was submitted with the date after crucial date. It is true, my lord.
No, I'm not on the crucial date. Come to that certificate. At page 46.
Yes, my lord.
See the
46, yes, my lord.
see the year.
Here is
First
mentioned.
paragraph, last line is below 8 lakhs for the financial year 24-25.
25, yes, my lord.
But you say you have taken out an annual certificate of only 2022
No, my lord.
in your reply.
Lordship, we bring it on record by way of the affidavit in reply. My lord.
I got it.
We are
So
trying.
that stand is also not corroborating. On a 22 annual certificate, an EWS of 24-25 cannot be issued.
Yes, my lord. Well, in format, that is, my lord, here is mentioned 24-25. But if he my lord, informed that his in my lord,
I'm sorry. You did not have it on the last date. Where is that stipulation that all this thing has to be available on the last date, Ms. Borua?
Yes.
There is a condition somewhere in the end.
6.3.
6.3.
Page 21 of affidavit, writ petition, lordship.
Okay.
Closing date of receipt online.
Yes, Mr. Counsel.
closing date is 31/12/2023. Crucial date.
And on that day, you did not have this certificate.
Well, at the time, he has the copy of this income certificate.
Income certificate is not EWS certificate, Mr. Counsel.
Lordship.
Then
If he provided the facility.
how can on the date of the document verification,
As well.
even if that is provided to you, you cannot have a retrospective
That was
certificate.
accepted, my lord. Right or wrong, he has
Fine, they have
submitted,
accepted,
lordship.
they have said that we verified, we found that this is not correct. So
That is natural violation of natural justice.
Fine.
Why, my lord? At the time of document verification, if his certificate.
where is the law to that extent? Where is the law? Even if the certificate is not in terms of the conditions of the advertisement,
My lord.
if it is accepted, that
My
becomes the Bible. Where is that?
That is accept. My lord,
Where is that law? Show me that law.
on that, my lord, on the basis of the advertisement, it ought to have been rejected at the time of the, my lord, document verification. my lord.
They have
And he ought to-
they have considered you as an unreserved candidate and given you appointment in BSN. You accepted that, you joined that. Thereafter, you resigned.
Yes, my lord.
You say you resigned, they say you have deserted.
Yes.
Fine. Anything more?
That is the case, my lord.
Anything more?
Anything, my lord, we are, my lord, trying to argue that the natural justice has been violated in this case. my
We'll
lord.
take care of that.
My lord.
Anything more?
No, my lord.
Ms. Burua, anything more?
No, lordship.
Yes, what is your name?
K. Roman, my lord.
K. Roma. Heard Mr. K. Roma, learned counsel for the petitioner. Also heard Ms. S. Burua, learned counsel appearing for the state, for the respondents. CGC appearing for the respondent. The challenge in the present writ petition is to the non-consideration of the case of the petitioner by the respondent authorities for an appointment by considering his EWS status and posting him to the CISF organization. Also, the petitioner in the present writ petition, in pursuance to an advertisement issued for a recruitment to Central Armed Forces, Central Armed Police Forces, Secretariat Security Force, and Rifleman in Assam Rifles, had submitted his candidature for the said purpose. The petitioner, while applying for the in pursuance to the said advertisement, had so applied by choosing the EWS category for the purpose. Also, On completion of the said selection process, comma, the petitioner being shortlisted, comma, was asked to appear before the concerned authority for document verification. Also, on the date of the document verification, the petitioner had produced a EWS certificate dated 1/8/2024. Also, it is contended by the petitioner that thereafter the respondent authorities had published the final select list, and therein the name of the petitioner figured at serial number 3297. Right?
Yes, sir.
3297. Basing on the said, basing on his such placement in the selection process, the petitioner was issued with an appointment order appointing him as a constable in BSF. Also, the petitioner proceeded for joining in his training. However, he contends that the said appointment not being to his liking, comma, he had submitted his resignation therefrom. Also, being aggrieved by non-consideration of his case for appointment in the CISF organization by construing him to be a candidate belonging to the EWS category, the present writ petition has been instituted. The Learned Counsel for the petition submits that the petitioner on the date of submission, on the last date of submission of his application in pursuance to the advertisement dated, employment notice dated 24/11/2023, had the requisite documents for procuring the EWS certificate, but unfortunately, the said certificate could not be procured at the relevant point of time. He had submits that subsequently the petitioner, before the date of document verification was so fixed, had procured the said certificate. The Learned Counsel for the petitioner submits that on the date of the fix for document verification, the petitioner had duly produced the said certificate before the concerned authorities, and no objection thereon was taken by such authorities. However, he submits that the petitioner in the final select list so published was not construed, not placed therein by construing him to be a candidate belonging to the EWS category, but was so placed by considering him to be a candidate belonging to the unreserved category. But the Learned Counsel for the petitioner further submits that on account of the fact that the petitioner was so placed in the select list by construing him to be a candidate belonging to the unreserved category, comma, the petitioner came to be selected for appointment as constable in the BSF Border Security Force. The Learned Counsel for the petitioner submits that in the event the petitioner's EWS status was reckoned, comma, he would have been selected for the post of constable in the Central Industrial Security Force, comma, which was the force of his liking. Also, the Learned Counsel for the petitioner further submits that the respondents, having not rejected the EWS certificate, was produced by the petitioner on the date of his document verification, comma, the non-consideration of the case of the petitioner by reckoning his EWS status had caused great prejudice to the petitioner, and accordingly, the present writ petition has been instituted by him, praying for a direction upon the respondent authorities to appoint him against one of the posts advertised belonging above one of the posts of constable advertised of the Central Industrial Security Force. Anything more is to be added? Ms. C. Borua, Ms. S. Borua, learned CGC, submits that the advertisement in question, more particular in clause 6.3, had categorically laid down a stipulation to the effect that The crucial date for a candidate to claim SC, ST, OBC, EWS status would be the closing date for receipt of online applications. She submits that the said stipulation would mean that a candidate applying against in pursuance to the said advertisement must have the requisite eligibility criteria, which would place him within the categories of SC, ST, OBC, EWS on the last date of submission of the said application. She submits that in the event the said application is not so being required to be uploaded with the application form, the original of such application would be required to be produced at the stage of document verification in the event the person concerned qualifies in the selection process. She submits that the application that would now be mandated to be so produced on the date of document verification ought to be a certificate obtained by the petitioner, obtained by the person concerned before the last date of closing of the selection, last date of submission of applications. She submits that the petitioner herein on the date of document verification had produced a EWS certificate, which was dated 1/8/2024, and the same was admittedly obtained much after 31/12/2023, that is the last date fixed for submission of applications in pursuance to the advertisement dated 23. She further submits that the said application of the petitioner on being examined by the competent authorities and the same being found to have not satisfied the requirements of the advertisement in question, the petitioner was not considered as a candidate belonging to the EWS category, but was considered as a candidate belonging to the unreserved category. Also, she submits that the petitioner, even after being considered as an unreserved category candidate, was found to have qualified for appointment as a constable general duty in the BSF post, and accordingly, he was issued with appointment orders in this connection. Further, she further submits that the petitioner was required to report at the, what is STC? STC, BSF, Chakur, Maharashtra, for completion of enrollment for formalities. She further submits that the petitioner reported for at the training center on 21/1/2025. However, the petitioner was found missing from the camp with effect from 24/1/2025. Accordingly, she submits a FIR in this connection was lodged before the concerned police station, before the jurisdictional police station. Also, she further submits that thereafter the petitioner had informed the authorities of the training center that the petitioner is unwilling to join BSF and had also forwarded an application dated 24/1/2025 in this connection. Also, she submits that the petitioner, having joined at the training center after being offered an appointment in the border security force, his selection in pursuance to the advertisement dated so-and-so has come to a logical conclusion, and the present petition has been so instituted as an afterthought. She submits that the petitioner, in view of the fact that he had not fulfilled the criteria stipulation set out in the provisions of clause 6.3 of the advertisement dated 24/11/2023, would not be entitled to have his case considered for appointment as a constable in the CISF. Anything more left out? Nothing?
No.
What did he dismissed?
Obliged.
May I please, your lordship? Lordship, Mr. Kyal is still on legs in court number 5, your lordship.
He was in court number 10 before.
5, your lordship.
5.
Yeah.
Matter is going on.
Yes, your lordship.
Seems to be a very big matter.
Lordship, we have 6 matters there listed today, your lordship.
We'll wait, my lord. We'll wait, my lord, till he's free.
We will not wait because we'll have it at in the second half after the matters are over, because it may take, how long will you wait? We'll have it at before 3. Come ask him, picks up, come back. Whenever you're here, just inform.
With your lordship, here the respondent authority have to file affidavit. Till today, they have not filed affidavit. Otherwise, we have challenged the selection process, lordship. I am the applicant for the post of lordship. Fishery Resource
Mr.
Management.
Bodhakar.
Lordship.
We'll file it, my lord.
You file it, but why have you not filed it?
Otherwise, lordship, the issue is that, lordship, after the game is over, they have changed the criteria, lordship. It is squarely covered by the test focus, lordship.
One more opportunity, my lord, I will file it.
Right. And then, lordship, their selection is completed, lordship, the persons are enjoying, lordship.
No, right now, my lord, all selection process have been halted because Vice Chancellor has superannuated, my lord. So now they are looking for.
So in pursuance to this advertisement, no appointment has been made.
No, my
Two
lord.
persons were appointed, lordship. 2 persons were appointed. My department is not appointed.
What happened to the fresh selection process?
First selection process, lordship says directed us to participate.
Without prejudice.
Without, we are,
That is not finalized.
that is not finalized.
Earlier one, 2 appointments
Two
already.
appointment was done, lordship. In respect to our post, no appointment was done, lordship. And
Or in fishery department, no appointment.
no appointment was done, lordship. So, lordship, give a last chance, otherwise, lordship, it will be. And even, lordship, the persons who were appointed, lordship, they have given the mark, PhD marks benefit illegally, lordship. While they are in the survey, they are in the students' research period, that period is counted for giving.
Research period cannot be counted.
Cannot be, that part is given, lordship. My lord judgment is there, lordship.
Okay.
So, lordship gives a
But
last.
Mr. K. Gugui, Learned Counsel for Deputy. Mr. Majumdar, you are appearing for us? I see.
They have filed affidavit, they have not much role,
Nothing to
lordship.
say. Also heard Mr. M. You are appearing for?
My lord, respondent 1, 2.
And Mr. I also heard Mr. I. Bodhakur, Learned Standing Counsel, Agriculture, Assam Agriculture University, appearing for respond number 1, 2, 3. Mr. M. K. Majumdar, Learned Standing Counsel, ICAR, appears for respond number 4. None has entered appearance for respond number 5, although service has been, a service of notice upon this of respondents is complete. Also, Mr. Bodhakur prays that he be granted immediate
Time till, my lord, 26th of March, my lord.
done, or time till 26/3/2026 to bring on stand by way of filing, bring on record the stand of the respondents represented by him by way of filing an affidavit. So, prayer accepted. Mr. I. Bodhakur, as a last chance, is granted time till 26/3/2026 to bring on record the affidavit. Full stop. In the event the affidavit is not so filed on or before the next date of listing, this court would require the registrar, Assam Agriculture University, that is the respond number 2, to be present before this court on a date to be so fixed, along with the records, to assist this court in towards disposal of the present writ petition. Registry to list this matter again on 6/4/2020.
Oblige.
Lordship, here, my lord, petitioner was engaged as ASHA worker. But in the year
You were working in 2015.
2015.
Show me a single document after 2015 that you're working.
But my case, I have two prayer, my lord. One is I have prayed area remuneration, but another prayer is that, my lord, till date, my lord, I have for working some facilities are required, my lord.
So you have not been working till now?
Work, but not properly because
No, you have not been
because
working.
to work, my
See, you are not even having the basic requirements a ASHA worker has to have. Where did you approach the authorities for that? Where is your letter? Where is your representation? You are there from 2015. You filed this case after 10 years.
but earlier I have
See, ASHA workers are very important segment of our health
my lord,
sector.
my submission.
A
for
person like
working
you,
as ASHA worker,
damage is to the public.
Facilities are required, my lord.
That you have not even mentioned in your petition.
No, I have mentioned, my lord.
Where?
In paragraph, my lord.
It
That is, paragraph, my lord, 10.
Okay. Without this, how will you work? You can't work.
At least I am right now,
What
my
work were you doing?
till date I have.
No, what work, Mr.
No,
Kandakar,
I
you were
am
doing?
not paying salary at least. But facilities, my lord. I am paying to issue to work for my working, my lord. Some facilities are required. At least that may be given, my lord. Because
But you have been already disengaged.
no, my lord, not in this English. Still, I am in engaged, my lord. Only the thing is that, my lord, I have paid arrear salary, but if they are disputing that, I am not praying. But I am praying rest, my second prayer, my lord. All facilities, my lord, is provided to other ASHA workers. That may be given, my lord, to me. That is my now prayer, present prayer, my lord. Only I am
Madam, have you disengaged her?
And there is no record, my lord, on inquiry.
You working?
No
Nothing is there.
things.
only, my lord, that my salary part they have replied. My facilities part they have not said anything, my lord.
No, they say that you have not worked in the field for even a single day.
My lord, for working, and as I,
Where is your letter that you are not being able to work?
my lord, I have submitted a representation also.
That is in 23, not in 15.
My lord, at that time they
You
are
were
saying
very...
anyway, my lord, till that since I have not been disengaged, my lord.
There is no question of
so
your
my
disengagement.
prayer, my lord,
This is only a contractual, this is a voluntary thing. You are getting an honorary, no salary.
So my humble prayer before my Lord is only I am praying it to provide some facilities is provided to other ASHA workers. That must be
Are you giving up the prayer for salaries?
giving up.
Giving up. Lekha. Heard Mr. M.R. Khandakar. Madam,
Yes, sir.
we will ask him to approach before you, submit a representation. If you find that he is required, engage him afresh by following the procedure and then give him all the things. If you don't want him, issue a speaking order to them. ASHA workers are very, very important cog in our health system in the villages. Without a ASHA worker, it's difficult now even for the common man to move forward. Everything an ASHA worker is required. Maybe very lowly paid, but their work is
very
important. Very, very important to the society. The heard Mr. M.R. Khandakar, Learned Counsel for the petitioner, also heard Miss. You are Miss
Evora.
A. Bora, Learned Counsel, Learned Standing Counsel,
NHM.
Health and NHM, National Health Mission, appearing for the respondents. The petitioner in the present proceeding has prayed for a direction upon the respondent authorities to release to her area remuneration with effect from May 2015, along with the current remuneration upon pursuant to her engagement as ASHA worker with effect from When were you engaged?
But 13 May 15.
13/5/2015. The petitioner has also prayed for direction upon the respondent authorities to extend to the petitioner the requisite materials / facilities enabled towards facilitating her to discharge her duties as a ASHA worker. Also, Mr. Khandakar at the outset has submitted that the petitioner would not press the prayer for being authorized area salaries with effect from May 2015, and accordingly, the said prayer would be not considered by this court. Also, Mr. Khandakar submits that he would restrict the prayer in the present petition. Submits that the petitioner would restrict a prayer in the present petition to a direction upon the respondent authorities to extend to her the materials as well as materials / facilities to facilitate discharge by her the duties of a ASHA worker. Right? Also, the petitioner, in pursuance, petitioner was wide a communication dated 13/5/2015 issued by the Subdivisional Medical and Health Officer, Gazari Kandi EPHC, engaged as a ASHA worker and was allowed to work in such capacity at Nis Sirahua village under Beganar Bhita sub-center with effect from 15/5/2015. In terms of the prescription made in her engagement in the prescription made in the communication dated 13/5/2015, the petitioner convened a meeting of the, what is that meeting?
It is in Panchayat level, there is a
Village Health Committee. Village convened a meeting on 28/7/2015 for constitution of a village health sanitation committee. Also, accordingly, in the said meeting, the said committee was constituted along with resolutions taken for opening a joint account in the name of the president of the committee and the petitioner herein, who was the secretary of the committee. Also, the petitioner projects that thereafter she was continuing to discharge her duties. However, on not being provided with the requisite materials / facilities as mandated to be so provided to ASHA Karmi for ASHA worker for discharge of her duties, the petitioner was left without any work to discharge. Also, the petitioner specifically mentions that she was not provided with a vaccine carrier, vaccine cards, medicine, etc. And accordingly, she was not in a position to discharge her duties. Also, it is in the above background that the petitioner has instituted the present proceeding. Mr. M.R. Khandakar, learned counsel for the petitioner, submits that the petitioner not being extended with the requisite facilities, was not in a position to discharge her duties and accordingly prays for a direction upon the respondent authorities to provide to the petitioner the requisite facilities as extended to similarly situated ASHA workers, and thereafter enable the petition thereafter to permit the petitioner to discharge her duties in terms of her engagement so affected by the communication dated 13/5/2015. Also, Ms. A. Bora, learned counsel for the respondent, have submitted that the petitioner at no point of time had approached the departmental authorities and or the NHM authorities raising a grievance that she was not being facilitated to discharge her duties as an ASHA worker. She submits that the petitioner was not found to have discharged any field duty after the date after her engagement as an ASHA worker. Also, she submits that the petitioner accordingly would not be entitled to any remuneration. However, she submits that further submissions in this connection is not being made as the petitioner, learned counsel for the petitioner, is not pressing the prayer for release to the petitioner of her remunerations with effect from May 2015. Also, with subpara, Ms. A. Bora further submits that the petitioner has not submits that no material has been brought on record to show that the respondents had deliberately not furnished to the petitioner the requisite facilities for discharge by her of her duties as a ASHA worker. She submits that the petitioner after 2015 had fully approached the respondent authorities in the year 2023 by way of submission of, she submits that the petitioner projects that she had approached the respondent authorities in the month of March 2023 and thereafter in the month of February 2025, raising grievance with regard to the provision not being made for providing to her the requisite materials for discharge of her duties as an ASHA worker. Ms. Bora submits that the said representations are not found in the records of the respondents, right?
Yes, my lord.
And accordingly, the petitioner be put to strict proof thereof. I have heard the learned counsel for the parties and peruse the materials available on record. The petitioner in the present proceeding had prayed for also, Mr. The learned counsel for the petitioner having not pressed the prayer of the petitioner for being released her remunerations with effect from May 2025, the said issue would not call for a consideration by this court. Also, the other prayer made in the present writ petition is for a direction upon the respondent authorities to provide to the petitioner requisite implements, facilities as provided to similarly situated ASHA workers and thereby facilitate her to discharge her duties as an ASHA worker. This court finds that the petitioner was engaged as an ASHA worker on 13/5/2015. Thereafter, she had convened a meeting for constitution of the Village Health and Sanitation Committee on 28/7/2015. Thereafter, in the present writ petition, thereafter, the materials brought on record by the petitioner in the present proceeding, it is not discernible that the petitioner had discharged any field duty after her such engagement made in the year May 2015, made in May 2015. Also, the plea taken by the petitioner of being prevented from discharging her duties as an ASHA worker due to the non-issuance to her the requisite materials and making requisite provisions for discharge by her of such duties attached to the that of an ASHA worker was found to have been raised for the first time by the representation dated 23/2023 before the subdivisional medical and health officer, Gazari Khandi BPHC. However, the respondents have denied the receipt of such representation and or the subsequent representations in the same lines preferred by the petitioner. Also, the petitioner, admittedly having not been found to be discharging her duties as an ASHA worker, and it not being evident from the materials available on record that in place of the petitioner, there was any other person engaged for discharging the duties of an ASHA worker in Nis Sirakhaung village under Bengalabita subcenter, this court directs the petitioner herein to submit a representation before the Joint Director of Health Services, right?
Yes,
Dubri.
No, madam, South Salman.
South Kalmara Mankacha. That is the respond number 4 here within a period of 15 days from today. So the petitioner in the said representation shall explain the works done by her, if any, after she was so engaged with effect from 13/5/2015. Also, the petitioner shall also, in her said representation, pray for being issued with the requisite materials for discharge by her of her duties as an ASHA worker. The respond number 4 on respect of such representation, in the event no alternative arrangement was made for the works of, for discharge of the works of ASHA worker in the village Nis Sirakhwa under Bengalbita subcenter, shall consider the claims made by the petitioner, and if the petitioner is found to be suitable for engagement, for continued engagement as an ASHA worker, necessary orders towards re-engaging the petitioner afresh, if permissible, afresh shall be issued, along with making provision for issuance to the petitioners all requisite materials so as to facilitate her to discharge her duties as an ASHA worker in the said village. In the event the petitioner is not found suitable for any justifiable ground, the respondent number 4 shall inform the petitioner about the same by way of passing a speaking order. The said exercise be initiated and concluded within a period of 4 weeks. From 4 weeks, there will be elections also in between. Within a period of 8 weeks from the date of receipt of a representation from the petitioner along with a certified copy of this order. It is provided that the petitioner will not be entitled to any remuneration with effect from 13/5/2015. Such remuneration would be so permissible to be extended to the petitioner only in the event she is so with effect from the date of her re-engagement in pursuance to the directions passed herein above.
I am deeply.
Yes, Mr. Das.
My lord.
Why the subsequent resolution of the governing body not taken note of?
My lord,
it's your case.
My lord, at the time of passing of this speaking order, my lord, the department had the communication of the principal of the earlier.
Now, there was an advertisement, Mr. Chetri, there was an advertisement. Then what happened? Just the sequence of events.
there was an advertisement, my lord, when I approached before this honorable court for regulation and all these things, my lord. Then as directed by this honorable court, I participated in the advertisement. And accordingly, my lord, there is an interim order passed by this honorable court.
That in that petition.
And meanwhile, since 2005, I work in the college.
No appointment in pursuance of that advertisement.
No appointment.
Was any appointment order issued?
No, appointment order has not been issued, only as per the direction, my lord, of this honorable court. Then it was remanded back, all the selection process, whatever it was done, my lord. And it was remanded back to the selection.
You were at serial number 2 in that selection process.
Yes.
And you say the first man went to Nagaon.
Yes.
He's no longer there.
No longer.
No appointment, no
No
finalization of the selection.
No.
Yes, Mr. Das.
Regarding second candidate, Malad, there is no provision in the act or the rules.
No. That second candidate thing did not materialize because this court remanded back the matter for a fresh consideration. And that was considered.
No, if my lord sees the orders, my lord, then remanded back to give weightage to the petitioners for her service of 15 years, my lord. And if my lord kindly have page 35, my lord. Page 35 below.
That's the order.
That was one of the orders, my lord. 4 lines from bottom, my lord. Planet Council for the applicant submits that the applicant also appears in the said selection process which was held on so and so. However, it is not certain as to whether the authorities have taken into consideration the existence of.
This is a college.
Yes,
the college.
Yes. However, it was not certain as to whether the authorities have taken into consideration the experience of long 15 years of service rendered by her in the said post.
Don't forget it. Come to 5.
Yes,
that 15 years experience.
So that was not certain whether that mark was given to her or not, petitioner. That's why that matter was remanded, my lord. Accordingly, after hearing the parties, the present application is
now you come to page 40, the subsequent decision.
My lord. 40, my lord. Operative part, my lord, 43. Here also, my lord, the court never said that the petitioner has to give 15 marks, my lord. Because the OM was never discussed in this order. 43, my lord. Accordingly, the matter is remanded back to the selection committee of so-and-so to comply with the direction contained in order dated so-and-so. That was the earlier order, my lord, which I have read. And upon taking note of the 15 years of experience, the petitioner to give adequate weightage in the selection process and thereby bringing the process to its logical end. That's it, my lord. Because till
so that 15 years of teaching experience, you had to give some weightage. Now you have a this is a selection of 2019. 19, my lord. 19. Now, what was the guidelines holding field in 19?
19, my lord, I have annexed along with my affidavit, page 64. This is the OM, my lord. And relevant parties, page 66. Distribution of marks. Bottom, my lord. Bottom 7. Teaching, library management experience in the concerned subject or domain.
Yes.
1 mark for each complete. Yes.
Yes, Mr.
Maximum 3 marks.
Lordship, that part was perused. That OM was perused before this honorable court. A record was perused, and the honorable court was came to the conclusion that since the person working
no, just come to that order of this court, first order.
On the basis of the honorable court's order, my lord, there is
in the first order dated 2110, this OM was not perused. It says, said long experience so and so for the post. So just consider, take into consideration.
And at that point of time, it was not certain whether he was, the petitioner was given weightage
Fine,
of
be that
cases.
as it. Now, when the second order was passed,
In the
where do you say that this was taken note of?
I have stated in my reply, man.
No, in the order.
In the
Page 40 onwards.
Lordship will find 40. The judgment, my lord, at page 40.
No, 43 is the direction.
Direction, my lord, as a whole, it needs, my lord, to go through it. Are Mr. So-and-so, Council so-and-so. Two, writ petition Srimati Gitari Bordoloi Das instituted this writ petition amongst others with prayer that either the advertisement dated 6/8/19 of the principal Shankardev Mahavidyalaya be set aside or direct the respondents to consider the case of the petition as regular assistant professor either by regular so-and-so sanctioning her post or by adjusting the petition in any vacant post. No credible submission has been made either to set aside the so-and-so advertisement for a direction so-and-so. But in course of argument that what has been brought forth before this court is that.
Yes, why did you not go up on an appeal on these orders?
Yes.
When there is a specific direction, which you project now to be violation of your OM.
But
why have you not gone up on appeal? Why did you allow these orders to attain finality?
no, my lord, here, in this order, the court never directed to give 15 marks, my lord.
But the 15 years was directed to
Yes,
be
yes.
taken note of.
Yes.
But you have not taken that.
Oh, my lord, kindly see page number 42, what had happened from 41, para 6, my lord. Mr. So-and-so learned counsel for the respondent, his college, my lord, has produced a communication from the principal in charge, that is so-and-so, to the director of higher education Assam, wherein it is stated and extracted. Here it says, however, it is for your kind information that so-and-so was appointed as an assistant professor in the Department of India on so-and-so against a non-sanctioned post, and since then she has been discharging her duty as assistant professor, and after the death of so-and-so she has been maintaining the classes of the department alone. Mr. Gitali Bordoloi also applied for the said post with teaching experience certificate of this college from the date of her appointment and appeared in the interview board, but the interview board selected Miss So-and-so for appointment in the post of assistant professor in Hindi on merit basis. But
when were you first appointed, Mr. Chetri?
Initially, I was appointed around 2005, my lord.
2005.
25/8/2005, my lord. Since then, I'm working as an debt.
So you had a PhD net slate from 2005 itself.
Every qualification is there.
2005 itself.
No, only I have MPhil, but other net slate
is not a qualification. Net slate you had.
Yes.
From 2005.
No, it obtained in 2008.
And PhD slate net slate.
MPhil 2007.
7 MPhil will not do. You require net slate or
Net
PhD.
Net slate already completed.
When?
In 2007 itself.
Net slate.
I'm coming to this one.
my lord, if my lord goes through this judgment, my lord, then it says that in para 7, my lord, what had happened before receiving the order of this honorable court, the
selection process was
over. That's why,
we understood. But let us see one thing.
That's why court observed that due weightage could not be given, perhaps could
But
not be given.
subsequently,
That's why that was
body
remanded back, my lord, again.
Para 2, lordship. In my petition, my lord.
Page?
Page 8. That the petitioner passed out the MA Hindi exam in 2005 and placed in second class, securing 57.7%.
Advertisement was of?
In 2019, Lord. And
so how can you be given marks prior to 2015? Prior to 2015. 2015 is the date when you acquired the UGC qualification for appointment as a assistant teacher?
No, 2000,
Because the minimum qualification is NET/SLET or PhD. MPhil is not a minimum qualification. You acquired that qualification in 2015. So the marking 15 years is marking for teaching experience. Cannot be different. It should be only for
my
teaching
lord,
experience.
since my lord, though my lord, at that time, my lord, she did not obtain this slate. But otherwise,
SLET is the minimum qualification, because why I'm telling you, where is that OM you just showed me? 64.
64.
Come to page 64. Relevant 66. Down below. That direction of this code has already been considered in the guideline itself. If you can come to the guideline at page 66. You are entitled from 2015. What 66 of the affidavit filed by Mr. Das.
yes,
Come down below.
yes.
Teaching library manager experience in concerned subject domain. 1 mark for each completed year of service after acquiring UGC norms. So and so, subject to maximum 3 marks.
But here, but I have also gone through this postgraduate teacher. That time also it was placed, and the honorable court in the postgraduate teacher, my lord, the person
Postgraduate teachers, he is the
not on that, just
lecturer.
just for lordship's information. Postgraduate teacher in the as per the rules 2018, my lord, where 60% this has been that part has been considered person who have completed more than 15 years, my lord.
In that 2018 rules.
Yes.
Huh. They are not required to pass that net. Huh. But that
60%,
that cannot be
60% marks.
That cannot be applied in a college, because college is
That's
by
true, my lord.
UGC.
Only that part. Only secondly, my lord, when this record was called for from the governing body, and this OM also produced by the standing council of the department, my lord. And accordingly, after going through this, the OM, my lord, and this record, this honorable court was pleased to pass an order saying that these 3 marks would not be sufficient.
But it has not spelled out that in the.
That's my lord,
because today I can only go by that.
my lord, is
I
the
can understand what you are saying.
my lord, it is the prerogative of the honorable court what the order passed, my lord. But that fact I am just placing before this honorable court that that OM was placed and a record was placed before this honorable court. Then honorable court was pleased to consider my case, saying that no, these 3 marks will not be a person working since 2005. And now in 2023, you were saying that only 3 marks will be provided. No, that cannot be. At least the 15 years due weightage should be given.
Okay, let us see it in another.
That is the
Let us see it in another way. The selection is not cancelled till now. The selection, that order is there, which is under challenge. She admittedly is number 2 in the selection process. Number 1 is no longer there. You have already appointed him in some other place. Why she will not be considered?
My lord, for that, my lord, my submission would be in the act or in the rule, there is no provision for selecting or waiting list candidate, my lord. And
Yes,
for
she is not a waiting list candidate here,
Yes, my lord.
because no recommendation has come to you till now.
No.
Where is the recommendation made by the governing body?
For
the serial number
for
1.
first candidate.
Where have you taken it to the logical conclusion? Mr. Das,
Yes, my lord.
that will come when Rule 7 is applied by you. A order is passed under Rule 7, 1 or 2, whatever it
Yes,
is.
yes.
But here that situation had not arisen. By the time Mr. Chetri was already here. This court remanded back the matter. Forget the 15 per marks and all. We are not concerned. But now she is the first candidate and a recommendation is made in her favor by the governing body. And the other person.
But the recent recommendation, my lord.
That
Recent
is in terms of the
recommendation,
second order of this court.
but that recommendation is not as per the OM, my lord, in my humble opinion, because
We are
the
not,
marks.
we are not concerned with the OM. We'll make it clarify. But she is now the serial number 1 candidate in the fray. He's not interested. He's gone. That you have the material because you have appointed him in Nagaon College. Director.
Yes, ma'am.
So why her case will not be considered?
But that is not the case of the petitioner.
Forget it. That this is a writ court.
That is not the case of the petitioner.
That may not be the case.
In fact,
But this is the writ court. We are asking you why.
while remanding the matter,
We are not going into this 15th thing business. A matter remanded back, fresh resolution in her favor. Number 1, we'll take judicial notice already appointed by the director in another school, college. And you have a rule that 1 year or 2 year or 3 year, he cannot come back.
Yes.
So,
my humble submission is, my lord, while remanding the matter in earlier orders, my lord.
forget 15 marks.
Yes, ma'am.
We will clarify 15 marks not permissible.
That is not the case of the petitioner here, ma'am. They are
Oh,
for this court.
maybe, but this court can always ask you. Why can't we ask you? A poor lady is working from 2005.
Yes, my lord.
Oh, I'll have to issue orders under Jaggo and all the other decisions.
For regularization, my lord.
Why? And that will create problems for you. That will open up a Pandora's box.
She has participated, my lord.
Participated,
There is
selected. Where is that second resolution, Mr. Chetri, of the college?
page 50, my lord.
50.
Yes.
Mr. S. Das. Mr. B. Chetri, learned counsel for the petitioner, submits that even if the plea of the petitioner that she is entitled to 15 marks in the selection process for the 15 years of experience acquired by her, comma, is not permissible to be granted, comma, the petitioner at the time of consideration by the selection committee in its meeting held on 13/5/2024 in pursuance to the directions passed by this court wide judgment and order dated 21/11/2023 in WPC number 7667/2019 was the candidate securing the highest marks in the earlier round of selection, inasmuch as the candidate placed at serial number 1 had in the meantime accepted and joined Nagaon College as an assistant professor. Such appointment was made by the Director, Higher Education. He submits that even if the matter is viewed from the said angle, the petitioner is entitled to be so appointed, being the candidate now in the fray who had secured the highest marks in the earlier selection process. He further submits that the earlier selection process was not taken to its logical conclusion, inasmuch as the matter was pending before this court and there were interim orders operating in the matter. So, Mr. S. Das, learned counsel for the petitioner, submits that he be given 2 weeks' time to receive instructions on the said submissions made by Mr. B. Chetri. Also, prayer accepted. Registry to list this matter again on Past soy. 26 Parine, 26/3/2025. Giving you a opening, you now climb on that.
Math.
And this question of yours that select list is not there is totally false. Totally a misdirected thing. FRBM says you can have only one candidate. For some reason, that man is not there. But you made he's gone. Now, will you go through the expensive process again once more?
That is the process.
You have the pool, only you will have to direct the authorities to prepare a fresh select list. Come in. But if he is appointed, then finished. Then that selection cannot be taken forward. Otherwise, Mr. Borbia and I argued one matter in this line. Mr. Borbia, you remember? A very young Simanta Das. Something happened. And the order was not pronounced, it was pronounced against us. But in the, he appointed. Yes.
Only correction, my name, I'm not appearing for the petitioner there.
S. Das, Learned Standing Council, Higher Education Department. Oh, he knows it.
Much less.
May it please your lordship.
But here, my lord, I could not file the affidavit. I'm awaiting the instruction actually. I need some time.
Petitioner here was appointed as horticulturist in the year 1984. Thereafter, a commission was set up when the
Hydro, electrical.
and when the ACB was bifurcated into three parts: APGCL, APDCL, and APGCL. And thereafter, a commission was appointed where Judicial Commission led by His Lordship D.N. Barua was there.
Fine.
And they recommended that they should be appointed. And accordingly, he was appointed. But they have kept him in NPS, despite the fact that
When was he appointed?
in the first round, he was appointed firstly in 2004, my lord.
2004.
Sorry, 1994, my lord.
1994 where? In
BHPCL.
No. In APGCL?
My lord, BHPCL at that time, Karbi Longi, and after that, Section 15 came into picture, my lord.
Mr. Sharma, when were you engaged or absorbed in APGCL?
APGCL 2007, my lord.
2007. Where is your engagement order?
My lord, my engagement order is at page 34. No, 1 minute.
34 is something else.
97, my lord.
Page 97, my lord. My lord.
Okay. You accepted this.
Yes, my lord. But thereafter, I gave a representation.
Why?
Because, my lord, we should be, as per the Section 15 Act of the Act of Reconstitution, that is at page 30, my lord, we come to, my lord.
Page 0.
Yes, my lord. May I read, my lord? Every person who has...
Now, what was the concept of pension in BPHCL?
My lord, the BPHCL's employee were...
pensionable establishment?
Yes, man.
What is the pension scheme there?
Old pension scheme, my lord. Old pension scheme.
Where do I get it?
Yes, ma'am.
Where is your CPF deduction? What is your stand otherwise, Mr. Natali?
I am awaiting the instruction.
you have
Otherwise,
not received
otherwise, my lord, he retired in the month of December 23. All the benefits under NPS he has received.
Thereafter, he was
after that,
emboldened to file this case.
he has filed this case. My lord, filed the representation in the month of February 25. And my lord, in fact, he is relying on decision taken by the APDCL that some benefit has been extended to those type of some similarly situated. He, according to him, similarly situated MR have been given the benefit by APDCL. So now he is in APDCL. He claims that that benefit should be extended to him.
APGCL also.
Yes, my lord.
May I just read here, my lord, before my lord proceeds? My lord may just come to page 36.
Why the delay from 2007?
My lord, there is a judgment in this effect that the pensionable service and the account of pension upon representation upon.
I'm not on that.
Yes, my representation.
I'm not on that. I'm not on that.
My lord, it is not that I have.
Mr. Sharma, I'm
Yes.
not on the delay part or
Yes.
in connection with pension.
Yes.
I am in the delay part in challenging a decision that you will be covered by X or by Y.
My lord, I have given representation upon representation to
When did you give your representation?
every year, my lord, from 2008
Every year.
onwards.
Show me the law that every year you
Yes, my lord,
submit a
23 to
representation.
the 23 2008 for regularization, and for thereafter, my lord, on I have given on 2006 my for
2008 is the first one.
Yes, my lord. After I was appointed, that is at page.
So 2007, 2008.
Yes, my lord.
So the law is that every year you submit a
My lord, as an
representation
authority,
and it gets extended.
as an I have I have given representation upon representation. Every year I have given
That will
representation.
not extend the period of limitation.
My lord,
Or delay and latches cannot be explained.
my lord, I have a understanding in this, my lord. If I may pray, my lord, there is a chronological event that has to be understood pre my appointment. My appointment was as per the judgment of this
Then
honorable
why did
court.
you accept your NPS benefits?
My lord, I accepted my NPS benefits, but
How much did you get under your NPS benefit?
Hello?
How much did you get?
My lord, that is the amount is not there. My lord, may just come to my order. At page 76, page 74, round of litigation that happened before this. At page 77 is the effective part. May I read? ASAB. Yes, ma'am. The mistake was then done on their part. Because I was a BHPCL employee, they absolved me, and once they absolved me, it was their duty to put me under section 15. I was protected by the act. Now, can a delay and latches taken away the?
So, where is your material to show that you were already drawing a pension? You were in a pensionable establishment in Baito?
My lord, section 15 protects it. For that section 15, I made
No,
it.
section 15 you have taken me.
Yes,
Okay,
I'll show you, my lord. Section 15, I'll show it to you,
Come
my
to
lord.
section 15.
Yes. My lord, let me read out section 15 once again. Page 30, my lord.
Every person
who has been immediately before the appointment day, employment on a permanent basis, in an undertaking of the company shall become on the appointed day an employee of the state government, or therefore on the board, as the case may be, with the same term and privilege as to pension, gratuity, and other matters, as would have been admissible him if the rights in relation to the undertaking.
Okay, now show me.
Yes, my lord.
That if you had continued in BPCL, you would have been entitled to a pension.
Yes.
Where is that material?
My lord, page 66. On the first submission, I do not agree because the legislative intent is patent and clear that the employee should be absorbed regularly if they are appointed on a permanent basis. As I've already held as to the above, that this employment has been appointed on permanent basis.
No, where is that thing with regard to pension?
Yes, my
You
lord.
were drawing up, you were entitled to a pension there.
My lord, being a BPCL employee, I was drawing a pension, my lord. That is why
How
my
did you have drawn a pension when you are an employee?
My lord, I just show that, my lord. My lord may just come to the judgment at
This is a proposition with regard to pay.
Yes, proposition
there's
regard to
pension.
pay, and before that the commission, my lord, there was my lord, there's a commission at page 76, page 66. I'm showing it to you.
Show me one thing
Yes,
that
my lord.
BPCL was a pensionable establishment.
Yes, my lord, it was.
Where? You get an instruction, Mr. not whether that's a pensionable establishment.
Also,
Then 15 will automatically apply. If it's not a pensionable establishment, pension will not come in.
BPCL, my lord, the act, my lord may say page 32 once.
Yeah, you say.
Yeah, the entire act, I'm showing it to you, my lord, once.
Mr. D. Nath, Learned Counsel for the Standing Council, APGCL, prays that he be granted
But kindly give it 3 weeks time. I'll
4 weeks time to file an affidavit in the matter. Mr. S.P. Sharma, Learned Counsel, appearing for the petitioner, expresses urgency in the matter. So, in view of the above, while granting, in view of the above, Mr. D. Nath is granted 4 weeks further time as a last chance to bring on record the stand of the respondents represented by him by way of filing an affidavit. Registry to list this matter again after 4 weeks. It should be a pensionable establishment if 15 has to be applied.
It is a pensionable. I'll show it to you, man. The next, I'll show it to you.
You have not been able to show me.
It is there in the payslip, my lord. In the payslip.
What is there?
At the basic structure, my lord.
What is the deductions? Page?
Page 26. That is a deduction. And in fact, my lord, there is an observation to that effect.
Special allowance 00, SA 00, CA 00, CC.
I'm sorry, it is not there.
Well,
Not a pensionable establishment. Mr. Nath, take note of that.
I'll file an additional affidavit to prove that.
Mr. Nath Das, your item
Item
was?
number 19.
19. Yes, who is there? Elementary? Elementary education. You are there, Mr. Sharma? Who is for elementary? His case was not considered by the DSC.
Lordship.
Otherwise, he was eligible.
Lordship.
We are remanding back the matter to the director. Let the director examine, and if it is found
Lordship.
that he is eligible, his case will be placed before the DSC and orders be passed.
Lordship. Lordship.
Disposed of. Item number 19.
Lordship, regarding affidavit filed by the UGC, my lord, Lordship, kindly see is para 9. My lord, this is the statement they have given on the basis of regulation 10, not on the basis of regulation 18. We are claiming, my lord, promotion on the basis of regulation 18. Now kindly see the instruction,
No,
my
how
lord.
can you claim it from 17 in the terms of regulation 18?
My lord, regulation 18, when regulation 18 comes into
18
effect.
can't have a, you can't get benefit under 18 from a date prior to 2018, right?
It cannot be retrospective.
How can it be retrospective?
No, my lord, this decision is taken by the committee.
Forget the
Let's
committee.
get
The committee has made a mistake.
Now,
They
already,
have
my lord, in that regard, my lord, I'll show you documents, my lord. Same committee and same, my lord, board of management, my lord, recommended and already granted promotion to so many equivalent person, my lord, which is serving.
Who is
university.
appearing for the Tezpur University?
Earlier, Tezpur University, Mr. Nilanjan Deka appeared. Now he is no longer there. Come on, naam dekha se.
So, my lord, UGC regulation is not is not acceptable, my lord.
Get hold of the standing council Tezpur. There was
Tezpur
some lady here in the morning. Mr. Kayal, I suppose. Just check up with
My
Mr.
lord.
Yes,
Kayal.
Mr. Kail was there, my lord. last
Get-
I'll call him
get it.
after some time. Lord.
He really goes and yes.
my lord. My lord, already decided about irregular and illegality of my case also, my lord. Case 36, my lord.
Page 30.
36, my lord. Covered by Babul Ali, my lord, which is earlier decided, my lord.
36.
Yes, my lord.
Nileshwar Borua.
Yes, my lord. Case 38 is, my lord, 11%. 38 and 39. The petitioners were appointed as assistant teacher in various LP school in the district of.
But the screening process is thereafter in terms of a division bench order.
My lord, before my lord, Babul Ali screening committee was my lord. Here, my lord, page 96, my lord, in my affidavit, my lord. Here stand also there, my lord, that screening committee was, my lord, application was invited in screening committee. Here, my lord, para 5, my lord. Yes.
Now show me that you come within this. Where is your pleading to that effect?
Yes. In my affidavit.
That you were an OBB teacher.
Yes, my lord. Page 36, my lord, there is order of Honorable High Court, my lord. This court, my lord. Page 36, my name is there. And page 38, my lord.
You come to page 20, that's your appointment order.
Yes, in appointment order, there is nothing, my lord.
Then show me how this appointment order came into being. Where is the selection?
Yes, my lord, the central scheme at that time, my lord, OBB.
Where is that? Where is that selection? There is no requirement of a selection under a central scheme.
Yes, that may.
Then, Mr. How can we?
My lord, give me 1 week time, my lord. I will install that. If there is, my lord, something I will bring in
If
record.
there was something, there ought to have been here. You have filed a reply also. No further time is being drawn. Judgments will have to be understood in the context of the facts.
Yes, my lord. And page 38, my lord, that is, my lord, clearly mentioned that under Operation Blackboard scheme, my lord. We are
Okay,
appointed.
I understood. But
That
where
six
is
hundred-
the material to show that you were appointed after a process of selection? And you yourself participated in the screening process.
Yes. And it is further pleaded that the names of the petitioner figured in the list of 610 posts which had been retained by the government.
Where do I get that?
Page 38, my lord.
Page?
38, my lord. In my order, my lord.
Where is your name here?
Yes, my lord. First, I am Dhuleshwar Borua, my lord. Annexure 5, petitioner number 1, my lord.
Yes, Mr. Sharma. There is an earlier order of this court that his case is covered by Babul Ali and others versus State of Assam and others. Hmm?
24.
Then it is submitted the bar that the petitioner has filed an affidavit in reply to the affidavit in opposition filed by the state respondent. However, the same is not tagged with the records of the case. Registry to list this matter again on 31/3/2026 along with the said affidavit in reply filed by the petitioner. We'll see. I think there is already a finding. How can you go beyond that? And why did you participate in the screening process if there was an order in your favor?
That is, my lord, during that time, my lord, all of my lord, teachers who are, my lord, appointed screening committee invited, my lord, that if
Lordship, in fact, in this stipend teacher's lordship, that there is a list prepared by the director who.
He is said to be included in that.
Lordship, if he's said to be included.
Then why
lordship,
did you go and do all these things
then
against the poor man?
Lordship, if his name is there in the list, lordship, he's in that.
It will go anywhere.
Blush.
We'll see. Yes. Now you have The criminal case has been answered in favor of the petition. This is admittedly a stigmatic one. How could you have done without a notice?
My lord, for that, my lord, this judgment will cover, my lord. Ajay Kumar Haloy case. Only remedy is the civil court, my lord.
No. This is not stigmatic. This is stigmatic.
My lord, in that case, my lord, stigmatic, non-stigmatic court doesn't went there, my lord.
Where is the material to show that he was being extended from time to time?
Lordship, the last extension, my lord, page number 24. That was up to 33/2020, my lord.
But he was terminated on
Before that.
28/8/2019.
Yes, during that contract period, my lord. And the Ajay Kumar Haloy
What is
says,
this? Ajay Kumar Haloy.
Ajay Kumar Haloy says, my lord.
Oh, Gritco, everything is there. But here there is nothing. And you have not even brought on record any material connecting him.
My lord, the impugn order was passed by the district commissioner, my lord.
Hmm.
We don't have that record, my lord.
So it is not even passed by the authority who had appointed him.
Appointment was also done as per the district commissioner's recommendation, my lord.
But that he is not.
Because he is the DPC, my lord.
What is the
District,
DPC?
district
Project
project
coordinator.
coordinator.
But that has to be approved by the departmental authorities. Where is Ms. Devi?
Or lordship may fix on Tuesday or something, or any other date, my lord.
No, we'll take it up today only. You get her.
Yes, my lord. I'm asking her to come, my lord.
Yes, Ms. Das.
My lord, according to my instruction, he was re-engaged way back in on 14 December 2021.
Yes, what is your case?
My lord, this is not new appointment.
Forget it. What is your case?
My lord, I was appointed as a driver in 2015.
Permanent driver.
No, my lord,
Then?
contractual.
Contract.
But there was no any contract between us, my lord. Contractual, but in a permanent nature, my lord. Because there was no any contract between us, and also, my lord, by a notification, they have appointed.
How long did you work
My lord,
after
from
joining?
after 2015, my lord.
You were engaged.
My lord, in 2019,
you were, terminated when?
2019, my lord, when FIR was lodged against me, my lord. On the basis of the FIR, and I was acquitted from all charges in 2021, my lord. In 2021, I was acquitted. Then I filed a representation, my lord, to reinstate me in my initial.
What was your remuneration when you were working?
6,000, my lord.
Fixed remuneration.
Yes.
That means you are not working on permanent capacity. And what is the error in this order? 24/9/2019. Your conduct at that point of time, court, they found it that it's not, because you will be in a public utility. Serving in a public utility, such conduct is not there. They have then engaged you. Now they have engaged you back on 14/12/2021. Have you accepted this?
My lord, I have not accepted this. Because
You have not joined.
If I join, my lord, I will lose all my consequential benefit as well as
What
my
consequential benefits are you going to lose?
My lord, from 2015, I have worked, my lord.
I'm
My-
sorry.
And my lord, that's why they have regularized the service, my lord, 620 among with the 620 members, they have, considering the vacancy, my lord, they have regularized. So,
Others have been regularized.
yes, my lord, that's why, considering the position, my lord, vacancy position.
Yes.
Nobody was regularized, my lord. I don't know.
As per my information, they have regular.
There is no instruction that
Then
they
how
will.
can you pass this? What is this provision of 6(4)?
No, this is misquoted.
That how?
This is
So
misquoted.
you are exercising that
No,
power?
this is misquoted, my lord.
It could be only a suspension, not more than that.
Yes,
Then
but we have immediately reinstated after he was exonerated from all the criminal
No,
charges.
why did you reinstate him? Then this could have been at best a suspension, not more than that.
My lord, this order, my lord, we may come up with an affidavit if lordship wants.
Sorry, you have not come up with an affidavit.
My lord, the thing
We
is,
will not permit you to come up with an affidavit.
no, my lord,
2021 matter.
no, my lord, what is there?
Now tell me, what is the power to issue this stigmatic order?
My lord, this order is,
stigmatic.
in my respectful submission, my lord, this order is not stigmatic.
It is stigmatic.
The only thing is misquoted the provisions of law.
The thing says that because of his involvement in a criminal case, he has been set aside. The work quality is not a question here. Suitability is not a question here.
Kindly see the last paragraph. Therefore, on the basis of the report and in the public interest and the image of the corporation, Series so-and-so is hereby released from service from his released from his contractual service immediately.
That is, I was acquitted,
After that, he was acquitted, he was reinstated,
not reinstated,
reappointed.
reappointed.
It's a contractual employment. What right he has, my lord?
She says that others have been regular.
That is what I wanted
Because
to.
620
No, 622 employees were released from service, and this has been upheld by this court, Miller.
That much I know, but she says somebody has been released.
Let
So
it,
you get the details, we'll take it up after some time. Who has been regularized?
who has been regular? I don't have that instruction.
She'll get it after, we'll take it up. You're not working now.
No, my lord, from.
Very good. Now to gone, everything gone.
See, he was given appointment, my lord, immediately after the exoneration.
You're only a contractual employee, madam. What right do you have?
My lord, whole situation arose my.
We interfere with this, no problem. We interfere with this. But you having not rejoined, you will be at their mercy. If they want, they'll take you. If they don't want, they'll not take you. But for the period you have not worked, how will you get any salary? There is nothing called notional fixation required to be made. You're a contractual employee. Should have acted on that 21 if you are, maybe you don't require a job. You're well off. Get that 622 correction. When you have it, tell her. Yes.
May I please? My lord, this matter regarding the termination from service, my lord. Earlier occasion, your lordship.
No. Show me that you are a regular employee.
My lord, after my lord appointment letter, my lord,
Where is the selection here? Or in Karbi Anglong, no selection is required.
page 13, my lord, approval for appointment, my lord.
But what is this approval based on? Where is the selection?
Election, my lord, I have not annexed, my lord.
Then there is no selection.
My lord, my case is, my lord, otherwise, my lord, also that, my lord, after rendering, my lord, more than, my lord, 14 years, my lord, he was, my lord, terminated, my lord. And my
They
lord,
have given a reason for that. What is your reply to that?
initially, my lord, they started disciplinary proceeding against the petitioner, my lord, but subsequently it was not continued, my lord.
Yes, Mr. Chutia.
The petitioner was, my lord, as per the, my lord, service rule, my lord, the period of probation is 2 years. And his appointment is only for a particular period, my lord.
Where do I get that?
My lord, lordship will look into, my lord, annexer to page 15. It is a only for appointment, only for a period of 3 months, my lord.
Then why did you continue him? You also posted him.
My lord,
transferred him,
my lord,
then you
during the
yourself
provision, my
extended
lord,
that.
Lordship, if you lordship will look into the Assam Pharmacy Service Rule, period of probation is 2 years. During the 2 years, my lord, he has to submit the medical fitness certificate, and he has not
Where is
completed.
your reason for that? Where have you, where is the reason? That it is because of this fact that he was not continued with.
My lord, Lordship will
He
look into his
continued for
own
14
statement
years.
in the, not my lord, Lordship will look his own statement in the repetition. Page 5, para 2, my lord. He was suffering from schizophrenia from July
Got it.
2011.
Got it.
My
But,
lord.
he was appointed on
2009, my lord.
9. So,
December 2009.
so
And the
from
period of probation,
2011, he is not serving.
not serving, my lord.
You're not serving.
Not serving, my lord.
2015, I got salary.
My lord,
As per
his
their own
name
record,
is
my
not in the, my lord, finance department portal, my lord. He's not drawing salary. He's not taking, my lord, not drawing salary. He's not
Okay,
getting
where is your displease in your affidavit?
My lord, page.
No, Mr. Chutis.
My lord, lordship will look into, my lord, page, para 4, page 3 of our affidavit, my lord, is not numbered. Para 4, my lord. That the petitioner was temporarily appointed as pharmacist on so-and-so date by the Joint Director of Health Service and posted at so-and-so for a period of 3 months, subject to approval from SIU. That approval was not there. Subsequently, the petitioner was transferred by the order to so-and-so, and he joined in the year 2011. But the petitioner remained absent from his official duties on a regular basis since the month of July 2011. So he did not complete the period of probation also, my lord. And
So if he was not there from 2011,
my lord,
why you waited till 2015?
my lord, he was suffering from schizophrenia, my lord. So a medical board was constituted, my lord.
22.
Medical board also found that he is suffering from.
So how can it be unauthorized?
My lord,
There is a reason for his absence.
my lord, there may be, my lord, as a person, pharmacist, my lord, lordship may look into it, there are 2 aspects, my lord. To be a pharmacist, my lord, he is required to be registered before the pharmacy
That is
council.
not the ground on which you have terminated his service.
That as he has not completed the period of probation, he has not submitted a medical certificate.
Mr. Chutia, you have yourself put him to a medical board.
My lord.
The medical board's finding justifies his absence.
My lord.
End of the matter, it cannot be taken as
My lord. My lord, but regarding, my lord, confirmation of service is required, my lord.
That is a decision which is not before this court. You have not taken that.
My lord, so he was released, my lord.
Okay, let us come to the release order then. Page 25 is the release order.
My lord.
Release order in my read petition.
Read petition, my lord, page 24, my lord.
24.
20?
24, my lord.
But there is a letter dated next page 25.
My lord.
I wait. 9. Before that.
Before that, my lord.
With reference, I have the honor to forward application so and so. In this regard, I would like to inform you that service of Abhijit Hozerika pharmacist has been released from Karbi Anglong due to irregularities of duty. So and so, so and so. How can you?
My lord, it is, my lord, subsequent, my lord, order, lordship will look into the impugner page 24, my lord.
That is why
that
we
is only
wanted
simple
to know.
release, my lord.
That is why we wanted to know
My
what
lord.
was the ground of this.
My lord, that is only the, my lord, that he has not, the appointment order itself says, and the SR 10 specifically says that for.
Chutia, just show me that these are the grounds basing on which this was done.
My lord, so lordship, the file, my
We
lord.
have been asking you for the file.
My lord, so
the
my
last around 3-4 days.
My lord, so my lord, the person, my lord, joint director is presently suffering from, my lord, health issues is there. He has submitted a, my lord, application today, my lord, to us, my lord. Subdivisional medical health officer is here, my lord, in the court itself, my lord. He brings the record, but the record does not have anything, only the paper. So I asked him to bring all those records, my lord. That is the factual part, my lord. He's sitting in the bar room, my lord. The person, my lord, he came, my lord.
Mr. J.
So we can-
Learned Standing Council KAAC submits that.
Lordship may hear the matter and without the records also, my lord, lordship may dispose of the matter, my lord.
We'll have to allow it.
Lordship, Lordship, my written argument, Lordship may consider my written argument, pass the order, my lord.
That means you are not producing the records.
No, I'll produce the records. If your Lordship grants time, we will definitely produce the
I've
records.
been granting you time.
My lord,
till
my
now.
lord, my lord, my lord.
Mr. S. Chutia, J. Chutia, Learned Standing Counsel, KASC, submits that the officer who is to produce the records, that is the Joint Director of Health Services, Kabi Anglong, has requested him to pray for an extension of time to produce the records as he is presently undergoing treatment for presently
chemotherapy,
undergoing
my lord.
treatment. Full stop. Prayer accepted. Registry to list this matter again on 31/3/2026. In the event the records are not produced, as records as directed are not produced, this court would pass appropriate orders as would be called for in the matter. And now we are going to impose heavy cost.
Lord.
Just show me that these two grounds we have done, because you cannot terminate him on the ground of unauthorized absence.
My lord.
Because you yourself placed him before that.
Lordship may interfere.
We'll have to.
My lord,
And if I interfere, then it will be with back wages.
my lord, my lord,
And we will make your officers responsible.
my lord, my lord.
Matter may come up for further hearing.
No, it will come up otherwise also.
Obligement.
Item to give. Yes, Mr.
My lord, I have done from my lord the queries put forward by my lordships, my lord, that whether this MIDC employee can be, my lord, given the pension and there is a delay in approaching, my lord.
You have received your VRS benefits.
That is correct, my lord. That is correct. So, my lord, I need some time, my lord.
No time is required.
To satisfy my lord, because my lord, I have even have not prepared the case today also, my lord. So, my lord, it will be for the
That we will help you with the order so that you can prepare for the next round.
No, my lord. Just one after my lord 16th, my lord, maybe please to fix any date, my lord. There are certain issues, my lord, which my lordship gives me an opportunity to satisfy. My lord.
You are asking for pension.
My lord.
You are asking for pension after accepting the VRS benefits.
My lord,
No issue, no issue, no issue. You can. Now you come to page 61.
61, my lord. Yes, yes.
Show me from there that you are a pensionable establishment. I can show you straight away that you are not a pensionable establishment.
My lord,
If you come to 2(1).
No, that is correct, my lord. This
That is correct means?
PPF due for both employees and employees contribution.
That's the end of the matter.
No, my lord, even then, my lord, the situation in which, the situation by which we have been compelled to enter.
What is that situation? Tell me.
Lord, that's why, my lord, I need some preparation.
But that situation you need not.
No,
require.
my lord may keep it as a part.
I'm not interested to keep it as a pattern. I don't want to have these matters being pulled around. Unnecessarily giving these people a wrong. If you have a case,
No, my lord.
just place it, we will consider.
My lord, I will try to satisfy, my lord. Just a chance, my lord. Just a chance. One chance. After 16, my lord, maybe please to fix it. After 20, my lord.
It is on 21st.
My lord, it is on 20.
Kundina pari, ido episode.
My lord.
23 episode.
26th, my lord.
2-4. On the
April,
prayer of
April.
Mr. Pusop. Heard Mr. A.R. Bhuya, Learned Counsel for the petitioner. Also heard Mr. N. Upadhyay, Learned Standing Counsel. Irrigation Department. The petitioners in the present proceedings have prayed for a direction upon the respondent authorities to authorize to them regular pension under the provisions of the Assam Services (Pension Rules 1969). The petitioners herein are found to be employees of the Minor Irrigation Development Corporation. It's called Minor Irrigation Development Corporation.
MIDC, my lord.
MIDC. Also, the petitioners on the closure of the said corporation were extended with PRS benefits in terms of the notification dated 13/5/2005. The petitioners have accepted the said benefits. So, the said corporation is not a pensionable establishment, and accordingly, the petitioner's hearing would not be entitled to receive pension and pensionary benefits under the provisions of the said rules or under the provisions of the Assam
1969.
Services bracket pension rules 1969. Also, posed with the said query, Mr. A.R. Bhuiyan, Learned Counsel for the petitioner submits that he be granted time till 2/4/2024-26 to make his submissions of the matter. Prayer accepted, a registry to list this matter again 2/4/2026. If you have something, bring it. We'll see.
My lord,
Lordship,
I'll try to satisfy my lord.
Obligement.
Yes, madam.
We have filed our affidavit, Lordship, already.
You have filed your affidavit, there is no problem.
Yes, Lordship.
But
A record also available. Last occasion record,
Ah.
needed to bring record, Lordship.
page 56.
Yes, please. This
There is
what is
no-
contradictory.
There is no specialist here.
Yes, there is
It's not required. A specialist-
guidelines require, my lord.
No, we have as per review medical examination, Lordship, and petitioner was X-ray report is there, Lordship. That as per that.
Is there
numbers-
is there a report with that X-ray?
Yes.
X-ray sheet, along with that X-ray sheet, is there a, just show me that. This is the review boards.
Yes, Lordship.
At page 56, my lord, the X-ray report it is stated that shows corpse angle 56. And the conclusion is mild
Page 50?
56. This review medical examination report. This close to brief of review medical examination and finding thereof. X-ray whole spine reveals corpse angle 56. Mild lumbar scoliosis.
Is this not being able to be detected by the eye examination?
Yes. 56 is severe,
The
they're saying
scoliosis,
mild.
there are some characteristics.
Yes,
One
Lordship.
is up, another one will be down.
6-degree.
No, that 56-degree is a major one. There will be a hunchback.
Yes.
When you selected him for that height and all, was this not brought to your note? Couldn't come to your notice?
It should be obvious.
Mr. Chetri, if you want to argue, you can argue.
At the time of PST and PET,
Ah.
only physical standards.
If he is having a hunchback, 56-degree would be something like this.
Yes, that not be find out by that DME board, Lordship. It is duty of.
And your first medical examination declared him kyphosis. That is that abnormal
Kyphosis is knee,
Oh. Spine,
yes, sorry.
spine. That is an abnormal spine thing.
Yes.
Now this body, the review body finds him for another one, lumbar
Lumbar
scoliosis,
scoliosis,
which was
yes.
not there in the,
Not in,
we are interfering with it. Don't appoint him, but
Yes.
place him with before a
Another review.
review medical board and a specialist.
specialist.
Otherwise, Mr. Chetri, your petitioner looks to be not a very fit person. He seems to have some problem.
Legal reports are okay.
Lumbar scoliosis is given, a condition is given.
Yes, Lordship. Towards left side.
But the findings is contradictory, my lord. It's stated 56° and then it is stated mild.
Region of medical unfitness, one kyphosis also mentioned here. But
Just a moment, just a moment. Where is that? This is
an excerpt 856, page 56.
See, this report which you have given
My lord.
has not done a detailed examination. It's just a basic thing.
CT scan also done, my lord. We have filed an additional affidavit. CT scan report is at page, my
Page?
lord, 100 at in the additional affidavit. Original is 101.
Yeah, Upendra Chauhan.
My lord.
This is on, this is done after the Kokrajhar Medical College report, Lordship. Kokrajhar Medical report is of 30/10/24 and it is 11/12/25 after filing the writ petition, Lordship.
Yes, it is with the leave of the honorable
If
court.
that is there, that will be there then.
Task
Now also.
Honorable Court directed to bring the record, this is medical reports on record. At the time, after that, he has done the CT scan, Lordship. Before that, I am objecting as because he does not annex the X-ray report or other medical
X-ray report
reports.
is there
But
in the petition.
that's why Honorable Court
Report is
bring
there.
that record.
X-ray
After
All
that,
these disputed questions, why should we go into? One
So that's-
body has,
that's why the
and they
prayer
have
is
done it on the basis of some reports. Why should we go into this now?
That's why the prayer is only limited to another examination.
No, one examination is final. Supreme Court has also said that. No.
On the same facts, this honorable court has allowed petitions, my lord. I have
where
annexed the
there is,
judgments there.
there is confusion in the report, then that
This court had remanded
Yes.
back the matter. Here, there is no confusion.
At page 56, my lord, it is, they're saying the Cobb's angle is 56°, but it is saying mild lumbar scoliosis. So it cannot be mild. This is contradictory, clearly. If it is
56 would be severe.
If it is 56, it would be severe.
unfit on account of lumbar scoliosis towards left side.
Okay, we are giving it back to you. Making one more examination.
Yes.
But Mr. UN Chetri,
All of
counsel for the petitioner.
All Oscar.
Or,
All Oscar.
all Oscar, learned counsel for the petitioner. Also heard Ms. S. Borwa, learned CGC. The petitioner in the present writ petition has assailed the findings of the medical boards that is the detailed medical examination board and the review medical examination board reports which had held him to be ineligible or unsuitable for being enrolled as a member of the CRPF. Also, the petitioner here, CRPF.
CRPF, Armed Forces, Central Armed.
So you have been selected for CRPF.
No.
Conducted by CRPF, RME
Oh, I see.
conducted by.
For Central Armed Police Forces, CRPF. No? Also,
Yes.
the petitioner herein had submitted his applications in pursuance to a notice dated 24/11/2023. By which a recruitment process for recruitment against posts of constable bracket general duty in Central Armed Police Forces, rifleman general duty in Assam Rifles was put up for recruitment by the Staff Selection Commission. The petitioner contends that he was successful in the physical standard test as well as the physical efficiency test. Also, thereafter, the petitioner was subjected to a medical examination, and therein the medical examination, therein the detailed medical examination board, DEB. What is it called? DEB.
DME.
DME. Detailed Medical Examination Board, DME. Not like it, Detailed Medical Examination. Found the petitioner to be unfit for suffering a condition called kyphosis, KYPHOSIS, which is an abnormal curvature of the spine. Also, the petitioner being aggrieved by the said report submitted an application for being examined by a review medical examination board. The prayer of the petitioner was accepted and he was directed to appear before the review medical examination board as constituted in the matter. The review medical examination board, upon examining the petitioner and also after perusing the report of the radiological examination carried out with regard to the petitioner's spine, proceeded to opine while its report dated 23/10/2024 that the petitioner was unfit for recruitment against any of the posts put up, recruitment against posts figuring in the Central Armed Police Forces on account of suffering from lumbar scoliosis, full stop, towards the left side, scoliosis towards the left side, full stop. The said report also indicates that the X-ray of the spine of the petitioner revealed a Cobb's angle of 56 degrees, and accordingly, he was held to be suffering from mild lumbar sclerosis, SCOLIOSIS, SCOLIOSIS, towards the left side. So, what is apparent in the records of the medical examination carried out in respect of the petitioner produced by Ms. S. Borua, learned CGC, appearing for the respondents, is that the detailed medical examination board had not opined that the petitioner was unfit on account of suffering from lumbar sclerosis, and it was stated that he was so unfit for the said recruitment on the ground of suffering from a condition known as kyphosis, KYPHOSIS. Also, although the review medical examination board had noticed the said finding of the detailed medical examination board, comma, nothing was brought on record justifying the said conclusions reached by the detailed medical examination board. Also, the petitioner projects that he had after rejection of his case by the constituted medical boards, comma, approached the doctors in the orthopedic department of Kokrajhar Medical College and Hospital. Also, the petitioner has brought on record the reports of the said Kokrajhar Medical College and Hospital, which negates the which indicates that the petitioner is not suffering from lumbar scoliosis.
Yes.
Scoliosis.
Lumbar scoliosis. Also, further, the reports reveal that the petitioner's top angle, the petitioner's spine was found to be within the prescribed degree of angle and to be not suffering, was found within 0 degree of Cobb's angle. Spine was found to be within 0 degree of Cobb's angle. Also, the above materials coming on record reveal a contradictory position. The reports of the detailed medical examination board as well as the review medical examination board and the report of the Kokrajhar Medical College and Hospital having brought on record contradictory medical opinions, the petitioner has instituted the present proceedings before this court. The respondents, next, in their affidavit, have disputed the said proceeding and submitted that the petitioner not having alleged any malafide against the doctors carrying out his medical examination, that is, the doctors constituting the detailed medical examination board as well as the review medical examination board, the conclusions reached by the said boards would not mandate an interference by this court. Ms. Borua has further submitted that the Honorable Supreme Court of India, in the case of in SLP bracketed C number 738-741/2022, involving issues similar to the one arising in the present proceeding, had observed that the decision of the review medical board should be treated as final. Also, I've heard the learned counsel for the parties and also perused the materials available on record. As noticed herein above, the reason for dismissal of the rejection of the case of the petitioner as medically unfit by the detailed medical examination board and the review medical board are distinct and separate. There is no averment brought on record that the reasons assigned by the said two boards are one and the same. This, when viewed in the light of the observations made by the opinion, this when viewed in the light of the opinion rendered by the doctors of the Kokrajhar Medical College and Hospital, comma, this court is of the considered view that the petitioner is entitled to have, is required to be examined one more time by a duly constituted medical board of the respondents. The reports the reports as noticed hearing above having brought on record contradictory medical opinions. The review medical board that would now be required to be constituted to examine the petitioner should also have a specialist in the field of orthopedics. Also, in view of the above, who should constitute that?
SSC divided the
In view of the above, the
CRPF, it is go to the CRPF lordship, as because RMU was conducted by CRPF.
in view of the above, the Staff Selection Commission authorities, that is the respond number 2, shall forward the petitioner to the competent authority for carrying out a review medical examination in terms of the directions passed herein above. The review medical board shall thereafter examine the petitioner in the presence of a specialist in the field of orthopedics and thereafter submit its medical opinion in the matter. Basing on the said report of the medical review board, consequential action as may be called for in the matter shall be so taken by the respondent authorities. In the event the petitioner is found to be medically fit, the respondent authorities shall ensure that he is recruited to the post to which he would otherwise be permissible to be so recruited in terms of his merit position in the selection process. Also, it is clarified that even if the petitioner is found to be medically fit by the review medical board, his appointment to the service involved shall be so made only in the event he comes within the merit position mandated for being offered such appointment.
May I please, Lordship?
Yes.
Petitioner may file representation before the CRPF, Lordship.
No. SSC will follow.
SSC, but SSC already they deferred him to CRPF.
But CRPF, whom will he go to?
Presiding officer here, review medical board, CRPF. Here is it.
Where is that? Where do I get it?
Respondent number.
Where is this board?
That is
Gauhati.
Gauhati, put it here.
Got it.
SSC liquidation report respond number 2.
CRPF Group Center, CRPF,
To me,
Gauhati, Amerigaon, Gauhati. Amerigaon.
but it's not a party here.
RME board is not party.
Board is not party here.
Board is not a party.
SSC can forward.
Yes.
To me, respond number 3 ko area. Regional director, staff selection commission.
Yes.
Huh? Regional director, staff selection. Respond number 3. Huh? So they said exercise shall be completed within a period of 15 days with effect from the date the petitioner appears before the review medical board now required to be so constituted. With the above observations and directions, the present writ petition stands disposed of. The records produced by Ms. S. Burwa be returned forthwith. Matidia.
Hello,
Kaya taasin no singhar taasin. Kaya lai siya 23 to matigini. One more matter, then we'll take up your matter, Mr. Yes.
Lordship, here in this case, promotion was given to him from 18/7/2018, when the UGC regulation came into force. This is my instruction, Lordship.
Know that. But why did you withdraw him?
Lordship, subsequently his case was considered and the
No, subsequent consideration is no grievance.
Lordship,
But why did you withdraw after giving it?
Lordship, because Lordship, there was a letter was sent to the committee. Committee
approved it.
Yes, Lordship, that was given to him. Letter was submitted to him also.
Not on saying. Why was it not given to him from 17? Why was it withdrawn? It was given to him from 17.
Yes, Lordship.
It was withdrawn.
No, Lordship. Earlier, he was not given any promotion.
Recommendation is there.
Yes.
Yes.
He was not given, Lordship.
Huh? There, come to page 69.
Lordship. Initially was
Come to page 69, Mr. Kyal.
Lordship.
Right?
Then Lordship, page 70.
No, I'm coming to that.
Lordship.
Sorry. This one, page 66.
Lordship, my lord.
It was given. How do you say it was not given?
Yeah, subsequently it was withdrawn.
No, it was withdrawn only in 24.
Yes.
Page 70.
Page 70.
What is the necessity to withdraw this? Why was it withdrawn?
Lordship, resolution of Board of Management as per the.
The Board of Management cannot have a overwhelming thing. One, you give something to a man, you withdraw it without any reason. What is the reason? Matter is pending from 24. The reason is not being communicated.
Lordship, subsequently his case was considered and is
We are not interested with that. His challenge is to page 70. We'll have to answer that challenge.
Then Lordship, may take
There is nothing.
Take up on Wednesday, I'll produce the record.
This is the problem. Your authorities are not responding from 2024.
Lordship, there was a turmoil in the university. There is no officer in the university as on date, Lordship. The BC was also removed and in his place.
That turmoil is past.
It is continuing, Lordship.
It was not there in 24, 25. It started sometime in middle of 25.
Yes, Lordship.
Then?
And Lordship, subsequently his case was considered.
That much of instruction your officers are not placing before this court.
Lordship, I'll produce the record on Wednesday.
We don't want a record, mister. We don't have that time.
To substantiate my.
You tell me the reason, that's all. Tell me the reason. Mr. S.C. Kyal, Learned Standing Council, Tezpur University submits that. He would place on record the reasons as to why the benefit of placement of the petitioner in academic level 11 of assistant professor as granted to him with effect from 3/5/2017 was required to be withdrawn subsequently. Also, in view of the above submission of Mr. Kyal, registry to list this matter again on Actress 31/3/2026. Yes, you've seen it. Notice. Yes, you are ready?
But, today I was adjusted my energy. If Lordship, my learned senior one.
No, we are not hearing it like that. We'll hear at one go.
Then on
I think I heard this once earlier.
A little, my lord.
on 11th, Lordship. If it is not inconvenient to my learned senior also.
No space.
Because Lordship, today I adjusted my energy. Lordship, but sugar is also.
He told me that his sugar level is gone down.
As agreed to by the Learned Council for the parties, we should not trouble him. When? Next week and the week thereafter time.
Can it be 26th, my?
27 I can. At 2 p.m.
Not.
Or we'll put it on 27. We'll see if you come and make a prayer. 2 p.m. we'll take it up.
Not.
As agreed to by the Learned Council for the parties, registry to list this matter again on 27/3/2026.
Much.
Now you don't be loaded. Go home.
No, I'm going.
Things heavy. Yes.
May please your lordship. My lord, first of all, this writ petition is not maintainable after my lord Junupa Bibi. Second, my lord, the petitioners violate the my lord terms and condition of the agreement, not
How?
me, my lord. Because my lord, kindly see, judgment dated, my lord, the page, page, my lord, the start page 32.
Hmm.
That
That is by the mother.
is filed by the my lord, the petitioners earlier return. This is the my lord fourth times of my lord, fourth round of litigation, my lord.
Okay, what condition?
My lord, that time, my lord, it was fixed that the my lord, both parties agreement with an agreement that 40% first wife, 40% second wife, and 20% to the mother. It should settle, my lord. Then after this, my lord, the second, my lord, the present writ petition is not, my lord, necessary, my lord. But she dragged me into this writ petition.
Because you were not sharing.
No, my lord, already they are, my lord.
So did you share
My lord,
40% to the?
that time pension was not issued. Pension was issued recently, my lord.
That's what I'm saying.
After this judgment, pension was issued, my PPO was
After
issued.
the pension.
Now, by this writ petition, she said,
Islam,
my lord,
after the pension had come to your account,
my lord.
have you shared?
No, my lord, I am getting 40% only. Because due
So
to
before this judgment, there was no fund.
no, my lord, no. And this petition is not.
Compel you to file this writ petition.
Yes. Page 28. Page 28. The pension was being divided between the two wives before the mother came in by the authorities. Things were going fine. Now comes the order wherein 40-40-20 comes in. Then comes page 37. This I may read, my lord. We have what we have essayed.
You have SL page 37.
Absolutely.
You want this to be cancelled.
We say 40-40-20 should be there.
Where is the provision to issue more than one PPO? Show me that. You can agree 100%, no problem, but the pension disbursing authority will disburse pension in terms of the rules holding the bill.
Absolutely.
And therein only one PPO can be.
Yes, I am not disputing to that.
Junufa BB is clear.
Correct. I am not even disputing to that.
If she is not paying you, go before the, what do you call that, maintenance?
My lordship,
File a maintenance application.
well, if I may put it this way, my lord.
You are not need to put it this way. That is the decision of the full.
Correct. I have gone through that, my lord. It is absolutely clear. I am not saying that. Otherwise, Second Life would not have it.
So you mean to say that after the order of this court, 40-40-20, she has not received more than 40% pension.
My lord.
No, she has not received it. But so far as page 28 is concerned, prior to that, when it is 50-50, agreed 50.
All those things gone. Now it will be according to page 36.
Page 36, if I may read, my lord. Page 37. If I may read, my lord.
37.
Yes, 36, correct.
That is correctly issued to the name of the first wife. There is no error there.
There is no indication of that.
It need not be. That's an agreement between you. She will comply with that. She will comply with that. And if she does not comply, go before the concerned court, file an application for maintenance. Junufa Bibi, penultimate paragraph.
Yes, Junufa Bibi talks about maintenance, but here is a case when there is an agreed sharing.
Any agreement cannot be dehouse the procedure laid down in the rules. She is holding it in trust. She will hold it in trust. She will then give it to you. If she does not give it to you, physically, if not possible, go and file a case. That's all. Nothing more, nothing less. You yourself have blocked your own.
What? Basically, we are on me. I can squarely follow.
I was not happy with the submission made by Mr. Islam that he is not going to share. It's not called for.
But that is their stand.
That is not called for. That we will ensure.
That is their stand.
That we will ensure.
I'm obliged. That was the stand. It's a very bold stand.
What I say is, Mr. Now,
My lord.
there is an agreement.
My lord.
You have to distribute. Give me the bank account number.
I have.
I'll incorporate it in the order.
You can pass it.
If you don't,
My lord.
I will ask them in terms of Junufa Bibi
My lord.
to appear before the
My lord.
file applications before maintenance.
My lord.
Along with an application before the treasury officer and the bank concerned that you are not sharing. And till the applications filed by them before the maintenance, before the competent court is not settled, you will also not receive.
I'm grateful.
Oh, my lord.
I think your client is resiling from the position.
He repeatedly
I
did.
told you,
My lord.
I'm accepting your position
My lord.
that if they don't, you don't give it to them, they will go before the
My lord.
competent court. Along with an application to the State Bank of India, whoever is the disbursing,
Bank.
and
No, no.
the treasury of jurisdictional treasury officer, and your pension
My lord.
till the completion of the proceedings before the trial court is complete, will be stopped.
Grateful, Lordship. Obliged.
My lord, stopping my pension is against the my lord Junufa Bibi.
I'll direct it. You go and appeal. Only because of your attitude. I'll record that you have disputed that position. That is why we have put this. Junufa Bibi
But I
cannot
leave
be
it-
utilized to make them suffer more. That is a beneficial order passed by this court. Now you can't crucify them with that, can you? And
No.
your attitude seems to be that.
I leave it, my lord.
I'm going to pass this on.
My-
Or will you share undertaking in terms of the earlier one?
Earlier order still hold the field, my lord. That is.
And why did you take that stand that you're not
Because-
going to share?
Because this writ petition is not maintainable.
Okay, this writ petition maintainable or not maintainable, we will see.
Well-
But why did you take that stand? It's not called for. You may have some bad blood for the second
Yeah,
wife.
my lord.
No issue. For the mother.
Earlier we are
Mother,
trying.
you are staying with whom? Another son, not with the daughter-in-laws. Both daughter-in-laws not looking after you.
No, I am very much agree from the very beginning, my lord, regarding the mother shares, my lord. And I have no dispute, my lord. Because she dragged the mother before this honorable court repeatedly, my lord. Not me, my lord. And initially, my lord, we are ready to settle amicably, my
20
lord.
mother, 40 for you, 40 for the second wife. In terms of the earlier orders passed by this.
My lord.
If not done,
My lord.
Junufa Bibi, along with an application before the, because if you misappropriate that money, from where will they recover tomorrow? They are not in a position to recover.
My lord.
This is
Writ petitioner. I gave for the writ petition.
Narji Begum. This
Narji
one.
Begum.
And what is this? Hey, write it down in a, how will I find out? Write it down in a piece of paper, bank account number, name, bank, branch. Give it to me.
I'm grateful, my lord.
Your client does not give me a good wife.
In fact, when we filed the writ petition,
Unnecessary writ petition.
no, when we had filed the writ petition, no, this attitude was there from prior. We
Oh,
approached
you
in
knew
person.
about the idea. Naturally, it will
we
be there.
approached it.
It will be there.
It will be there.
It's natural.
Natural. Then we said, pay her 40. Don't pay us. At least our portion be adjudicated. But we did not stop there. We said, something or the other, the man is no longer there. Let us somehow settle it out. We're grateful. In between came the full bench judgment. And they got bullet point. Therefore, I kept
Problem create my friend, my lord, not my lord, me, my lord. Because my lord, the first case, my lord, filed by the my lord, the second wife, then second, then third, my lord. This is the fourth case.
That should be the last.
My lord.
They should be.
My lord.
Or all
Consider
will
all
not have pension. I'll ensure that.
My lord.
I'm grateful, Lordship. Obliged.
Highly obliged, your lordship.
Dispose of. You write it down and give it to us. Hey, man. Itu design you can give it. Just write down whoever are there. Preemptive writ petition. Preemptive writ petition. Given?
Forward.
Yes. The currency of the termination or the contract, where do I find it?
My lord, page 24.
Okay. And the writ petition was filed on?
It was filed on Lordship February 2020. In fact,
Within the period this was filed.
Lordship, may I read the judgment, my lord? Listen, please. Para 11, my lord. May I read para 11? In the light of the facts as unfolded. My lord.
See, this writ petition was filed in the year 2011, right?
Yes,
This writ petition.
my lord.
The contract had come into end on 1/11/2010. So after the contract expiry, this writ petition was filed. So,
My lord, the ratio of the judgment is that.
ratio will be in terms of the facts.
Yes, facts is that, my lord, after the, my lord,
What I
termination
propose,
period.
Mr. Doctor, is we are not interfering. In view of the fact that the petitioner has also been now exonerated in the criminal case,
My lord.
this order, we treat it to be a show cause notice. She will file a representation within 15 days.
He will. Yes. Yes.
He will file a representation within 15 days. You take it into consideration in the light of the PASA appropriate law. And we are not reinstating him back subject to that order.
But Lordship, termination order was on the same allegation which was in the FIR.
I'm sorry.
My lord,
You want
benefits
me
of
on
doubts
merit-
will come.
You want it to be on merits, Ms. Devi, you make a submission, we will do that.
Lordship, there is also a judgment of our High Court, Lordship, where the reinstatement was rejected in similar cases, Lordship. And also the contract has already been completed on 21/11/2020.
And you filed this case thereafter,
No,
before that.
before that also.
And
This is availed by the division bench, Lordship. Since no inquiry was held or no opportunity was granted to the petitioner to defend his case, Lordship, in that view of the matter, it was directed to reinstate the petitioner in that case, Lordship. And the Honorable Division Bench also upheld this order.
This is on a different factual situation altogether. This is with regard to,
He is also lordship contractual employee. He was also contractual employee, Lordship.
maybe we can't ignore the allegations against him. Very serious.
But Lordship, may kindly see the bail order, Lordship. One of the accused has filed bail application, Lordship. In a bail application also, after perusal of the case diary, it was held at page 33, Lordship. It was a BDO who was also one of the accused in this case. Page 33.
My lord, preponderance of probability and benefits of doubts
You,
are different things. my lord.
in that case, the Assam Services discipline appeal rules were inbuilt into that contract. Here it's not there.
In fact,
this case also, Lordship, no opportunity was granted. Directly
Yes, Devi, if you want an opportunity, I'm ready to grant an opportunity.
Lordship, it was 2020, 2018, Lordship, already.
No, if they want, they can, if there is a
More than 8
vacancy, they
years.
can always.
one more thing, my lord. Lordship may kindly have
So-
page number 18, my lord.
Or I am bound by my own decision in Gyasali. I have rendered that decision. I've said cannot be. I've followed Gridco.
Yes.
And there is one more judgment of the Supreme Court.
My lord. Lordship may kindly have page number 18 once, my lord. This is the first engagement. And this is not pursuant to any, my lord, advertisement or something like that. It was just upon recommendation of DC, he was appointed as
Who
contractual.
appointed?
As per DC's recommendation.
Who appointed him?
Appointed, my lord, the project director, my lord.
So why did the project director appoint him?
My lord, because DC is the head of
Why
the.
did the DC passes an illegal order, you are bound to comply?
The approval of the deputy commissioner.
Okay,
That
that's
is
why,
why I'm
without a selection, how is the appointments made?
My
That
lord,
means we'll have to hold them up also.
my lord,
Your
it was,
departmental authorities.
it was long back, my lord. They may not now working, my lord.
This judgment will not apply.
And his contract was extended up to Lordship 33/2020.
And in between, you came before this court.
Lordship.
Okay. Anything more?
Otherwise, Lordship, in the implementation of the scheme, this petitioner has no role. As per the scheme, Lordship, page 30. Page 30, Lordship. It is a program officer who will personally monitor all the scheme and submit report to the undersigned. That is a deputy commissioner.
What were you?
Lordship, I'm a Rozgar Sahayak.
Gram Rozgar.
Rozgar Sahayak. I have no role to play in the execution of this work, Lordship. Page 30, Lordship, the scheme of the work. Implementing agency shall observe the necessary formalities. Implementing agency, I am not an implementing agency or part of the implementing agency.
But Ms. R. Devi, Learning Council for the petitioner. So had Ms. F. Learning, Standing Council, Panchayat and Rural Development Department. The challenge in the present proceeding is to an order dated 17/8/2018 oblique 28/8/2019, by which the petitioner was terminated from his contractual engagement as Gram Rozgar Sahayak by the Deputy Commissioner and Promotional District District Project Coordinator, MGNRETA, Menrega, Silobi, page 46. Also, as projected in the petition, the petitioner participated in a recruitment process for the post of Gram Rojgar Sahayak, and on being found to be suitable, he came to be appointed as a Gram Rojgar Sahayak on contractual basis in pursuance to the recommendation made in the matter by the Deputy Commissioner, District Project Coordinator, MREGA, Lokhimpur, wide and order dated 12/10/2020. The initial engagement of the petitioner was for a period with effect from 15/10/2012 to 14/1/2013. Also, the petitioner thereafter continued in his services as a contractual Gram Rojgar Sahayak. Also, the contractual engagement of the petitioner was thereafter extended wide an order dated 11/1/2013 till 30/3/2013. Similarly, the wide an order dated 27/6/2019, the contractual engagement of the petitioner was extended till 30/3/2020. Also, while the petitioner was so continuing, an FIR came to be lodged by the project director, by the Deputy Commissioner, Lakhimpur, against the petitioner hearing and others, alleging misappropriation of government money during execution of schemes mentioned in the said FIR. Also, the petitioner, the said FIR came to be registered as Narayanpur PS case number 174/2019 under section 120 bracketed B/409/403/420 IPC. Also, the petitioner was arrested in connection. You were arrested or you were PRS bail? Also, the petitioner apprehending arrest in connection with the said police case registered against him, approached this court by way of filing an anticipatory bail application being AB number 2829/2019. Also, this court wide order dated 29/8/2019 granted interim pre-arrest bail to the petitioner. Also, the said interim pre-arrest bail granted to the petitioner was confirmed by this court wide order dated 13/11/2019. Also, 13 pre-arrest bail was confirmed on 13/11/2009. Also, however, in the meanwhile, wide an order dated 28/8/2009, 17/8/2018 oblique 28/8/2019 by what the 19, the petitioner in services of the petitioner as a contractual Gram Rojgar Sahayak came to be terminated on the grounds as set out in the said order. Also, being aggrieved, the petitioner approached the Commissioner, Panchayat and Rural Development Department, Assam, by way of an appeal dated 12/12/2019. The said appeal not being disposed of, the petitioner has instituted the present proceeding. Ms. Devi and Devi, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the present writ petition was filed within the period of validity of the contract entered into with the petitioner by the respondent authorities. She submits that the order, impugned order dated 17/8/2018 oblique 28/8/2019 was so issued by the Deputy Commissioner and District Project Coordinator MREGA, Lokhimpur, without jurisdiction, inasmuch as the said authority was not the appointing authority of the petition hearing, right? She further submits that the present writ petition being so instituted, assailing the impugned order during the validity of the contractual period, this court would consider the issue arising in the matter as on the date of filing of the writ petition, and accordingly be pleased not to dismiss this writ petition, holding that the contract entered into in the matter with the petitioner has since lapsed. Anything more? Miss Devi, in support of our submissions, has placed reliance on a decision of a coordinate bench of this court, rendered wide judgment and order dated 10/9/2024 in WPC number 3/2019, Box Kulidb, Iqbal Hussain Laskar versus State of Assam and two others. And the order dated 7/1/26 passed by a division bench of this court in Writ Appeal number 361/2025, State of Assam versus Iqbal Hussain Laskar. Also, in the above premises, Ms. Devi submits that the order admitted having, Ms. Devi further submits that in the criminal case instrument, the police on conclusion found any incriminating material against the petition and FR. The case was returned in FR. Also, she submits that the criminal case having been not the charges in the allegations leveled, the unilateral conclusions drawn by the responding authorities in the order dated 17/8/2018 or 28/8/2019 would mandate an interference with the scope. Per contra, Mr. S. Dr. Learned Standing Counsel, Panchayat and Rural Development Department submits that the petitioner admittedly was a contractual employee and his period of contract was being extended from time to time. He submits that the last extension of the contractual appointment of the petitioner was granted till 30/3/2020. Also, he submits that the petitioner being found to be involved in misappropriation of government money while serving as a Gram Rozgar Sahayak on contractual basis, criminal proceedings came to be instituted against him. Also, he submits that the concerned authority, that is the Deputy Commissioner, District Project Coordinator MREGA, Lakhimpur, on an inspection of the scheme, construction of Band Road from Silikhaguri Road via Fulani Khat High School to Meramuk Sport Association under MREGA 2018/19 quotation close, and as well as the report submitted by the executive engineer DRDA Lakhimpur, it was found that the work was only done to the extent of rupees 68,790 However, expenditure of rupees 11,30,936 was shown as per the MIS report. Also, the petitioner being found to be involved in the said misappropriation of money, his services came to be terminated. His contractual appointment came to be terminated while the order dated 17/8/2018, oblique 28/8/2019. Mr. Doctor submits that the petitioner would be that the petitioner as on date cannot claim a reinstatement in service inasmuch as during the pendency of the present proceedings, his contractual appointment has already come to an end, and there being no interim order staying the effect and operation of the order dated of the impugned order dated 17/8/2018, oblique 28/8/2019, the petition after the lapse of his period of contract and his period of contract not having been extended, a repetition in the matter would not be maintainable. The petition would be required to institute appropriate proceedings under the provisions of the Specific Relief Act
64.
64 before the competent court of civil jurisdiction for redressal of his grievances. Also, Mr. Dotto, in support of his submissions, has relied upon the decision of the coordinate bench of this court in the case of Ajay Kumar Haloi versus State of Assam and others, reported in 2014 (5 GLR 560. I've heard the learned counsel for the parties and also peruse the material available. Like I'm going to Yasuddin Bul. It will maybe
1963, my lord, sorry.
63, a specific relief act,
1963.
relief act 1960. Let us see what we can do. Dispose.
High level.
I'm sorry, my lord. This was a misconception, my lord.
Huh?
Batch wise means, my lord, they have completed 8 and 10 batch. Now they will start from 15 batch, my lord.
What they come to?
Batch wise, they have regularized. I have
You're regularizing.
no. That's
They are an organization just surviving.
Surviving.
You have
May I submit one point? Court query is whether a contractual employee can be reinstated or not, my lord. I have a squarely covered judgment, my lord. I have submit. I think my kindly peruse. A similar situated person have already been reinstated, my lord, reported in Union of India, my lord. Hiran Borgohai. He was 15 batch, my lord. 2015, he was terminated and again he was reinstated.
Well, that was a termination, paragraph 13, your lordship will read, my lord. It was a termination, this is a release from the contract.
13 and 14 is the relevant.
okay. This is solely based on a police case.
My lord.
Now she is acquitted. This order goes. This order goes. Her continuation salaries all will be in terms of your 14/12/2021. But for any other purpose of like regularization or something of that sort comes up, she will be deemed to be an appointee of 2015.
That's all right, but she did not join in 2021.
Or she should not join.
She did not join. That cannot
My
be, my lord.
because of new appointment, my lord. He has not reinstated that.
He disobeyed this.
Hey, to cut it here. Heard Miss M. Das, Learned Counsel for the petitioner. Also heard Miss M. Das, Learned Counsel for the petitioner. Also heard Mr. Do you need more drivers now?
My lord, that I have to take instructions, but if he files an application, you may consider it.
Okay. Ms. M. Das, Learned Counsel for the petition. Also heard Mr. Dr. A. Somoha, Learned Standing Counsel, ASTC, appearing for all the appearing for the respond number 2, 3, and 4, while Mr. R.B. Goswami, Learned Standing Counsel, Transport Department for respond number. The petitioner, by way of instituting the present writ petition, has presented a challenge to an order dated 2/12/2019, by which, basing on a criminal case instituted against the petitioner, she came to be released from her contractual, he came to be released from his contractual service. Also, the petitioner hearing on in pursuance to an advertisement dated 12/2/2015 had submitted his application for being considered for engagement as a driver on contractual basis. The petitioner, being found to be suitable in the selection held, was offered engagement as a driver on contractual basis and was posted to the office of the divisional superintendent ASTC Sibahag. Also, in terms of the set recruitment, the selected person would be engaged as a driver come contractor and would be put under training for a period of 1 year. Thereafter, those found suitable would be engaged on contract basis with the ASTC City Service Gauhati. So, would be engaged as driver in Gauhati in ASTC. So, while the petitioner was so continuing, he was also transferred to various establishments under the Assam State Transport Corporation, bracketed ASTC. So, thus, the petitioner got involved in a criminal case and thus, one Nomita Patrobulwa lodged an FIR on 4/8/2019 before the officer in charge Tiok Police Station, inter alia, alleging therein that on 28/7/2019 at around 9 p.m., the petitioner, along with 2 others, had assaulted her son and snatched away 1 MI mobile phone from him. Also, the said case was registered as Tiok PS case number 366/2019 under section 419/392/394. The police on basing on the said criminal case registered against the petitioner, the Managing Director, Assam State Transport Corporation, proceeded wide order dated 2/9/2019 to release the petitioner from his contractual service with immediate effect by projecting that the image of the corporation was by projecting that the same was to protect the image of the corporation. Also, in the criminal case so instituted against the petitioner, the police on conclusion of an investigation submitted a charge sheet against the petitioner and two others. The trial court thereafter proceeded on their trial court on conclusion of the trial, void judgment dated 22/1/2021 passed in PRC number 693 of the 2019, proceeded to acquit the petitioners by holding that the prosecution had failed to prove the guilt of the accused person, including the petitioner, beyond a reasonable doubt of having committed the offense alleged against them. It was also noticed by the learned trial court that no incriminating material was found against the petitioner and the other two co-accused. Accordingly, they were released and they were acquitted from the charge framed under section 392, 394/34 IPC. The petitioner thereafter approached the managing director, Assam State Transport Corporation, via a company representation dated 15/2/2021, praying for his reinstatement in service. Also, the managing director, Assam State Corporation, thereafter, while order dated 14/12/2021, noticing the urgency and shortfall of drivers, proceeded to appoint the petitioner hearing, proceeded to engage the petitioner hearing on a fixed monthly remuneration of 10,000 per month, fixed monthly remuneration of rupees 10,000, and posted him to Gauhati along with others. The petitioner, however, has not accepted the said appointment, and a deed of contractual agreement was not signed in the matter. So, it is in the above background that the present petition has been instituted, assailing the said order dated 2/9/2009. Ms. M. Das, learned counsel for the petition, by reiterating the facts noticed herein, has submitted that the only reason behind the release of the petition factual service was his involvement in a criminal proceeding. They said criminal proceeding having subsequently being answered in favor of the petitioner, that is, he being acquitted from the charges framed against him therein, the order dated 2/9/2019 would mandate an interference from this court with a further direction to the respondent authorities to deem that the petitioner continued in his services after 2019 with all consequential benefits. Miss, any further submission? Any further submission?
My lord, means,
Huh?
my lord,
No,
My
no,
lord.
any more submissions?
no.
Ms. Das, in support of her, well, Ms. Das further submits that the order dated 2/9/2019 was passed by the authorities of ASTC without affording an opportunity of hearing to the Ms. Das submits that the petitioner not being found blameworthy in the criminal proceedings instituted against him. The order dated 2/9/2019 mandate and interfere. So, per contra, Mr. Dr. H. Omoa, Learned Standing Counsel, ASTC, submits that the order dated 2/9/2019 so passed on the petitioner being found to be entangled in a criminal case and the allegations leveled against him therein being found to be serious, which would have the effect of tarnishing the image of the ASTC, and accordingly, the authority is prohibited to issue the order dated 2/9/2019. Also, he submits that the petitioner being a contractual employee, the conduct as mandated to be followed by him not being found to have been complied with, the order dated 2/9/2019 would not mandate an interference. Mr. Tomoa submits that the petitioner, on being acquitted in the criminal case, having approached the respondent authorities, he was, in view of the need existing at the relevant point of time, re-engaged, engaged freshly, was given a fresh engagement as a driver, wide an order dated 14/12/2021, and was required to submit his joining report to the divisional superintendent ASTC Jorhat, and also to sign a deed of agreement for contractual appointment, for contractual engagement. Also, he submits that the petitioner had not had not accepted the offer made to him by the order dated 14/12/2021, and accordingly, he submits that the petitioner would not be entitled any relief. He further reiterates that the petitioner, being a contractual employee, would not be entitled to claim any remuneration for the period he had not served in the organization. Anything more? In the above premises, Mr. Dr. Samoa submits that the order dated 2/9/2019 not mandate any interference. Orderly. But the learned counsel for the parties at some length. Hearing remains inconclusive. Registry to list this matter again on 20/3/2026. Let me think what I can do.
Deeply obliged, my
Obliged.
You give me a printout of this.
my lord. Deeply obliged.
May please, your lordship. Here the affidavit is ready, lordship. By tomorrow it will be filed. The lordship may fix the matter after 10 days. Lordship.
Purnima Hore.
Yes.
Mr. P. N. Sharma, Learned Standing Counsel, Elementary Education Department submits that the affidavit in the matter on behalf of the respondents represented by him would be filed by 7/3/2026. Registry, Mr. N. Sharma, a registry to list this matter again on 27/3/2026. The Learned Counsel, the petitioner is at liberty to bring on record a rejoinder
If
to
required.
the affidavit, if so advised.
The suspension matter, my lord, petition is a constable, my lord. There is the father hearing, my lord. Right, my lord.
Yes, I know, we had submitted that his suspension was not reviewed, ma'am.
Gone.
Mhm.
Allowed.
Apply.
But you'll get this by Tuesday or Wednesday.
Fine.
You apply.
Fine.
Allowed. None, we can-
Lordship, here my telephonic instruction is, Lordship, that inquiry report has been submitted.
You said that there was no proceeding. There was a proceeding instituted.
Yes, my lord, not concluded till date, my lord. The hearing was taken, my lord, on March 2025, my lord, but no final order was passed, my lord. And I am in the verge of retirement.
When is your retirement?
Retirement on July 31, my lord.
July 30, 31. 2031.
No, my lord, 31/7/2026, my lord.
26.
My lord.
Yes, why a decision is not being taken?
Lordship, my telephonic instruction is that the inquiry report has been submitted to
So
the
finish
director.
the inquiry
Lordship.
within 1 month.
Lordship,
Done?
Lordship.
But Mr.
H.L. Oscar.
H.L. Oscar, learned counsel for the petition, also heard Mr. P. N. Sharma, learned counsel for the respondent. Learned standing counsel, elementary education department, appearing for the respondents. The petitioner in the present proceedings has prayed for a direction upon the respondent authorities for regularization of his period of suspension with effect from 21/6/2022. Period of suspension with effect from 21/6/2022 to 3/3/2023. And also for consideration of his case for promotion. Also, the petitioner hearing while working as an assistant teacher at Sushil Paul MV School, comma, where is your suspension order?
Lordship, suspension order, my lord, I had not annexed, my lord.
When was the suspension effective?
Reinstatement, my lord, page 14, my lord.
Came to be placed under suspension while an order dated 21/6/2022 pending drawal of departmental proceedings. Also, the petitioner thereafter was while order dated 3/3/2023 reinstated in his services while revoking the order of suspension in compliance with the directions passed by this court wide order dated 9/2/2023 in WPC number 7459/2022. Also, it is submitted at the bar that after the reinstatement of the petitioner in his services, a departmental proceeding was instituted against the petitioner. When was the show cause notice issued to you?
Propose notice, my lord,
Mr. Counsel, there is no disclosure in the writ petition. When was the show cause notice issued?
propose notice, my lord, not annexed, my lord, but 13/9/2022, my lord.
Where is it?
Lordship, I have not annexed, my lord.
You have a copy?
Lordship, in earlier repetition of the.
Please give it to me. Page? Page 13-9.
13/9/2022, my lord.
A departmental proceeding was instituted against the petitioner by issuance of a show cause notice dated 13/9/2020. The petitioner submitted his written statement against the said show cause notice, and the same being not satisfactory, it is contended that a inquiry officer and a presenting officer was also. The Learned Standing Council, Elementary Education Department on instructions has submitted that the inquiry has been completed and the inquiry officer has submitted his inquiry report to the disciplinary authority. He submits that the disciplinary authority would take a call, would take a final decision with regard to the would take a decision in the matter after the copy of the inquiry report is forwarded to the petitioner for his comments. Also, the revocation of the regularization of the suspension of the petitioner being only permissible to be so done on conclusion of the inquiry in terms of the provisions of FR 54B, this court at this stage would not be this court at this stage would not proceed to direct for regularization of the suspension period of the petitioner FRS without the completion of the inquiry, without the department proceedings instituted against the petitioner being taken to its logical conclusion. Also, further, with regard to the promotion of the petition, the petitioner being under a cloud after institution of a departmental proceeding against him, the case of the petitioner would have to be kept under seal cover in the event the same is so considered. So, in view of the above position and as agreed to by the Learned Council for the parties, the director, who is the disciplinary authority?
Director.
The director of Elementary Education Assam is directed to forward a copy of the inquiry report to the petitioner within a period of 15 days from today. The petitioner thereafter shall submit his representation against the same within a further period of 7 days. Also, on receipt of the said representation of the petitioner, the Director Elementary Education shall consider the materials coming on record in the inquiry along with the findings of the inquiry officer and the representation submitted by the petitioner and take a final decision with regard to the orders that would now be required to be so issued in the departmental proceeding drawn up against the petitioner. Also, along with the final orders that would now be passed by the Director, Secondary Elementary Education Assam, on conclusion of the departmental proceedings against the petitioner, an order be also issued regularizing the period of suspension of the petitioner. Also, it is further provided that the petitioner's case for promotion to the post of headmaster, if considered, shall be kept in seal cover and be opened only in the event the petitioner stands exonerated from the charges framed against him in the departmental proceeding so instituted. The exercise now required to be instituted in the matter, be instituted and concluded by the Director, Elementary Education Assam, within a period of 6 weeks from the date of receipt of a certified copy of this along with the above observations and actions, the present petition stand. Adjournment is Yes, why these promotions are not being made? You did one exercise in 2016. Thereafter, what happened?
My lord, I have a
latest instruction, it's like, it's not that we didn't try, my lord. In 23, my lord, we shot the director. This is the instruction from director, my lord. The director had written to the government for conducting the examination. In 24, my lord, we got a approval from the government. So there were some 189 posts. Thereafter, my lord, we approached SEBA because we don't have that expertise to conduct the written examination. So SEBA later on declined on 6/7/24 that they are not in a position to conduct the examination. Then, my lord, again we approached the government. Thereafter, again we approached, government gave us the approval to approach somebody else. GU, we wrote to GU, my lord, Gauhati University. Then chairman of the Assam Higher Secondary Education Council. Even of late, we have written to Cotton University even. Please, somebody conduct the examination. As soon as, my lord, we get whoever, my lord.
Where is the scheme? Where is the scheme? 11/4 something. Where is that?
11/4, sir.
Ah, 4 this.
One of this.
Okay, Mr. Dhar, come to page 33.
Page 33, my lord. Yes, my lord. My lord.
That was superseded. 4/6. Huh?
Yes, my lord.
When?
No, this is, my lord, this notification, my lord, of 2012. So, my lord, accordingly, we conducted, my lord.
There is no contemplation of a written examination here.
My lord.
It is on the basis of oral interview. 100 marks. B1, A, 2. So why this?
Maybe, my lord, now we have a new scheme.
Where is that? Your affidavit also does not say about this scheme.
My lord, this instruction is what I just submitted, my lord. This is the instruction of 18/2/26. So why now government is, my lord, seeking a written examination?
Mr. Adhoc,
I will get that clarified, my lord.
For the respondent. There are additional senior government advocate. Hearing for the state respondent submits that. The respondents are now on a lookout for an body to carry out the written examination for promotion to the post of Anganwadi worker against the 25% post reserve. This is for supervisor.
Supervisor, madam.
For supervisors. Also, the Learned Counsel for the petitioner submits that in terms of the notification dated 4/6/2012, the selection from the post of Anganwadi worker to that of supervisor is to be so done basing on an oral interview with distribution of marks as set out in clause B of the said notification dated 4/6/2012. He submits that the said notification does not contemplate a written examination. Mr. Dhar, Learned Counsel for the Learned Additional Senior Government Advocate, submits that he would receive his instructions in the matter and apprise this court as to why a written examination is being contemplated in the matter by the respondent and why such examination was held for the purpose of such recruitment earlier. Also, raised it to list this matter again on when?
My lord,
After 25.
Let it be, my lord, 31st. It's a Tuesday, my lord.
313. Yes.
May it please your lordship.
Respondent number 7 is the daughter of the first wife.
Yes, lordship.
And the petitioner number 2 is the daughter of the
Second one.
and petition number 1, second,
Yes, lordship.
right?
Yes.
And first wife is not there.
No, lord. She passed away.
How old is the respondent number 7?
Lordship, most probably under 18.
Under 18, minor, not married,
No.
minor. What is the problem?
Lordship,
Yes. Who is appearing? Which department? Irrigation. Oh. Yes, Mr. Chakraborty, you have.
We have nothing to do. Compensatory family pension, we don't do it.
You will not.
Director of pension release.
They are not releasing the pension till date.
no, lordship. Lordship, page number 15, para 13, lordship. Lordship, rupees 3 lakhs has been deposited in the account of the petitioner number 1. But when she approached the bank, then
They did not release it.
yes, lordship. But they have no instruction from the government.
Is anybody representing respondent number 7? Can you get hold of Mr. Upadhyay, Upadhyay? There is a council representing respondent number 7 also. We'll
Yes,
take
sir.
it up together, then find out a way. Your name?
Jidas.
Jidas, Lana Council, heard Mr. Jidas, Lana Council. There is no representation on behalf of the respondents. For the ends of justice, registry to list this matter, short dated out. 19/3/2026.
Lordship.
Remind me on that day. After informing them, we'll upgrade the matter and take it.
Yes, sir.
Pension matter should not wait. We'll see.
May I please, your lordship? Lordship, learned counsel has left the court for he has not feeling well, lordship.
Who was the learned counsel?
Mr. D.A. Kayum, lordship.
এখন পাইছা নে এফিডেভিট পাইছা এনে পাইছা তো
Perhaps the query which has been raised had not been answered on a proper level. मैं विचार करू शकतो.
Yes, what is your ground for challenge?
Lordship, actually, I am not aware about this case, lordship.
You have filed your affidavit.
Your lordship.
It's completely premature that I have bring to this affidavit, Your Lordship, because it is completely non-formal appointment, and as per FR 49C, it's only an executive order only, and all the statement made is contradictory to the order.
Is there a stay order? No, there is no
Yes,
stay order.
yes, MD.
No stay.
No stay.
You are continuing.
Yes, I'm continuing.
Continue.
And it is their version.
Let it be fixed on after 8th Lordship.
A prayer is made on behalf of Mr. D.A. Kayum, learned counsel for the petitioner for an adjournment in the case on account of personal inconvenience. Miss M. A. Oza, learned counsel appearing for the respondent number 4, submits that an affidavit in the matter has already been filed by her, and the same is available on record. Mr. D. Kaushik, learned standing counsel, Secondary Education Department, submits that the instructions received by him is not complete, and he prays that he be given further time to complete his instructions and file an affidavit in the prayer accepted. Registry to list those matters again after 6 weeks on a date to be fixed by it.
Right.
In the meanwhile, the state respondent shall bring on record their stand by way of filing an affidavit. You are continuing, you continue.
Yes.
Yes, Mr. Ali.
May I please, Your Lordship?
Last occasion. Last occasion, I am.
Relax.
Order dated, my lord, 31/2026, my lord, paragraph 5 and 6.
So this is the report.
Yes.
Not verified from the school.
Lordship.
The certificate is not verified. There is some doubt.
So, my lord, the departmental record, my lord, as per paragraph 5, my lord, department,
Which department?
the executive engineer, my lord.
No, your school certificate.
Lordship.
School certificate, there is no record there. And they found one Hussein, but it is not Anwar Hussein, it is Anar Hussein. Anar Hussein cannot be Anwar Hussein. So, Ms. S. Burwa, learned counsel.
Now, Lordship, in the service book, my lord,
Government advocate has placed on record an inquiry report submitted in the matter by the Office of the District Commission. Sorry. Also, Ms. Burwa shall furnish a copy thereof to the learned counsel. Registry to list this matter again on 5th. 2-4.
No, the retirement is 3-1.
Oh, tomorrow. Kali. Bye. Hey, like in a DD.
Tomorrow, my lord,
Tomorrow, Saturday, pension matter.
I have some.
Then very urgent.
Monday, my lord.
Monday, we are not possible. There are many people waiting.
Tuesday, my lord.
Kundina Pari. Retire, go back to 17. Oh, do one thing. 17 for Fada hearing.
Lost.
Make a mention. I'll upgrade.
Lost. Okay.
None appears for the petitioner on call. On the last date of listing also, there was no representation on behalf of the petitioner. So,
Actually, my lord, it is become infractious.
I know that. That's why they are not here. In view of the Mr. S. Dr. Learned Standing Counsel, PNRD department is present. In view of the above, the present petition stands dismissed for non-prosecution.
Alia,
Yes.
Well, I need some accommodation. Well,
Why?
SMT 60 has left the court due to some person. SMT 60 left the court.
No,
Due
Mr.
to some personal
you are there. But
Well,
why the orders are not being complied with? What is the problem?
I paid the order dated 2/2/2022, 2nd February.
The order violated is at page 13, 24/9.
12.
Huh?
Page 12.
Page?
12.
12.
Okay,
Relevant portion is page 14. Yes, madam. What happened?
Lordship, appearing on behalf of respondent number 1, your lordship, we were required to submit the documents to respondent number 4 for calculation of the pro rata benefits, your lordship, and we have done our part, your lordship. So once they calculate the pro rata
Yes,
benefits.
why have you not calculated that?
My lord, Berando.
In fact, my lord, as per my telephoning instruction, my lord, already the director has on 6th of March has passed an order, my lord, granting the pro rata pension, and the inspector has been directed to take the appropriate steps for do the follow up with the Assam University. Now, my lord, it will give us 2 weeks time, my lord, we can complete the process, my lord.
Mr. B. Kaushik, Learned Counsel for the petition, for the respondent submits that respondent number
4.
Morning.
4 is Inspector of Schools, lordship.
4, 5, 6, and 6 submits that the director has already passed orders towards compliance of the directions passed by this court by
6th
order
of
dated
March.
24/7/2019. And the same would be forwarded to the Assam University authorities within a period of
2 weeks, my lord.
from within a period of 2 weeks from today. Registry to list this matter again on 1/4/2026.
Okay.
On which date the compliance order shall be brought on record by the compliance group on it.
Okay.
Obvious.
Recover the amount from the retirement benefit, my lord. Kindly shift page 58. Page 58.
Recovery.
Recovery, my
How
lord.
much?
5,43,668.
Yes, Mr. Doc.
My lord, we just acted upon, my lord, we have filed our affidavit. We just acted upon, my lord, on the direction of this accountant general, my lord, the respondent number 5. That is what, my lord. Yes. There is, my lord.
You are acting on directions.
My lord, accountant general is a, my lord, a constitutional body, my lord. We have to, my lord.
How can a constitutional authority interfere with another constitutional?
My lord, I am a commissioner secretary. So if I go by that thing, my lord,
Where is that orders I passed, similar orders? Yeah.
Similar data.
The last day, something I passed in your case.
That it's on Wednesday, well, I. Otherwise, it is
Oh, Mr.
about my tropic machine, right?
Rafiq Mashik and the other cases.
Paragraph 18.
And anything to, is he involved in that overdrawal, Mr. Dhark? He's not involved in the overdrawal. Registry to list this matter again on (23/3/2026) for further hearing. Code 25 now.
Oblige.
Your lordship order has not yet been
23 for further hearing.
Your lordship order has not been complied with. That has been put to challenge before the division bench. That is also dismissed by my lord. And on the last occasion, if SLP is not referred before the honorable.
Here, my lord, director is seeking some formal proposal from the district authorities, my lord. Also some clarification.
For last 3 years, my lord, I am not getting anything. Retired employee.
When are you complying with? Now you can't. You will have to comply. When? Give me a date.
I need some time, my lord.
Why? Why? Who is seeking instructions in the matter from the district?
My lord, director.
Director is the person who put up the proposal. So everything is there. And now what again?
But
He is
here,
already retired. You have retired.
Yes.
some clarification is made there, my lord. Can I name
What
the-
clarification? Without clarification, he put up the proposal before the government. Will not work. Very weak excuse. Something better.
But this is the instruction I have received.
This
Same
instruction will not work. You have put up a proposal on your own. When was the writ appeal order passed?
7/11/2025.
7/11
2025.
in writ appeal number?
347 of 2025.
The Learned Counsel for the petitioner submits that the state respondents had assailed. Oh, yeah, I say. Mr. Bora, Learned Counsel for the respondent submits that an SLP in the matter has not been filed and the respondents are proceeding to comply with the directions passed in the matter. Passed by the order dated 2/2/2024 in WPC number 6013/2023. He submits that he be granted further 3 weeks' time to produce the order of compliance before this court. Prayer accepted. On the next date of listing, the Learned Counsel for the respondent shall place before this court the order order passed by the respondent, or the orders passed towards complying with the directions passed by this court, while the order reporter dated so and so in WPC numbers. Registry to list this matter again. 3 weeks, question. 31/3/2020.
Oblige me.
May I please, your lordship. Here in this case, your lordship, name correction of the petitioner's father, your lordships.
In the highest HSLC,
Yes, HSLC and HS,
where is the case law? Jigyap.
yes, lordships.
Yes, madam. What do you have to say?
I am appearing on behalf of my senior Mr. T.C. Shutia. Actually, sir is on leave due to his
Oh, his marriage, daughter's marriage. When is the marriage?
Monday, sir.
Monday,
Lordship.
next Monday.
Lordship. Lordship, kindly fix the matter after 2 weeks.
Okay. His daughter is.
Lordship.
A prayer is made on behalf of Mr. T.C. Shutia, learned counsel appearing for the Board of Secondary. What is it called now?
ASEB, Assam State School Education Board.
Assam State School Education Board. For an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the petition. Accordingly, registry to list this matter immediately after 2 weeks from today.
Date may be fixed.
2 weeks from today.
Otherwise matter not listed, your lordship.
On 1/30/2026.
Obliged.
Yes, Lordship.
Yes, Mr. Goswami.
This is regarding selection and appointment to the post of headmaster in BTC area. Already same matter has been settled by this honorable court. I have annexed the order. Now today they have filed an affidavit regarding lots of awarding of marks in by the state selection committee. And this court has already held there is no question of state selection committee before seniority and the 3 years HCL. So already this matter has been disposed of by this honorable court. I have annexed the order also.
Okay, we'll get that affidavit and then cover up that also.
I have annexed the order at page 90. Relevant portion at page 105.
Why is it come for orders?
Charges of notice awaited.
So, Chief, respondent number.
Private respondents there. From respondent number 7 to issue. Respondent numbers.
Service is not complete.
No, Lordship, in this particular case, one thing is very important. This particular respondent, notice has been sent by registered post with AD. And they were also party in the earlier writ petition filed by this Deputy Honorable Court. They were party. And that is why they were aware of the judgment, they are not appearing.
No, they are aware of the judgment, but are they aware of the subsequent case filed by you?
Lordship, notice has been sent on.
But here
Notice
we
for the
find
12th
that, Mr. Goswami, we find that the notices are not served. I can't go beyond this.
Also can see order dated, office note dated 12/2/2026.
12/2. Here, AD
Wait,
card only 10 and 14.
No.
7, 8, 9, 11 not received.
Lojima court's order dated 4/11/2025.
7 to 9, 11, 12, 13.
23.
So far as so and so awaited.
Only for respondent number 22.
22. 7 to 23 accepted.
That's it. Only 22.
Okay. We'll wait for some time. Yes.
Lordship, we have filed our affidavit.
What is the stand?
We are objecting, Lordship.
You're objecting. Okay. Mr. B.C. Musari, Learned Standing Counsel, BTC submits that an affidavit on behalf of the respondents represented by him has been filed today. So, registry to list this matter along with the said affidavit on the next date of listing. 1/4/2020.
Before that, if possible, also.
Badly tied up. 1/4/2024. So, the registry shall also put up a note with regard to the service of notice upon the status of service of notice upon the respondent number 22.
As per my lord, Lozima Court Order 24/2026.
See the office, Lozima Court order dated 24/2026, which fills that Peru's village. which reveals that the service of notice upon the respond number 5 is complete. Accordingly, registry to list this matter for admissions after 3 weeks on a date. Alia, mercy.
May please your lordship. Lordship, here in this matter, respondent number 4 has filed an affidavit in opposition on 2/3/26. So would like to file our reply. So for that, we need some more time, lordship.
You have effected service by Dusty on respond number 5.
Yes, lordship, yes. Also filed our Dusty affidavit.
The petitioner has filed an affidavit to bring on record the service of notice being effected upon the respondent number 5 by way of Dusty mode. So accordingly, the service of notice upon the respondent number 5 is held to be complete. The registry to list this matter.
The lordship interim shall be continued.
List this matter for admission after 4 weeks on a date to be fixed by it. Till the next date of this thing, the interim order passes.
Oblige.
Bless.
Please, your lordship. Lordship, I filed a RTI application before the district judge seeking certain information, lordship. And as per the RTI petition, they have given a reply wherein it is reflected that I can get the information through Lakhimpur district portal, lordship. But nothing has been, information has been get by the present petition,
Have
lordship.
you filed the second appeal?
Yes, lordship.
Then commission?
Yes, lordship.
Commission, what did it do?
On the
State commission.
yes, lordship.
Yet to be considered for hearing, though it has been registered.
Why not considered?
Lordship, it is, the matters are heard on a serial basis. So right now we are looking after the appeals which were filed in January 2020.
That's not the purport of the commission. Commission is expeditious.
It ought to be, but
Why it's not?
that to be, yes. I will not be in a position to answer with regard to why there is a. And we have also
So
filed
what
an,
is the,
we have also filed an affidavit bringing on record the
I
details.
got it, but why? Why this delay? This appeal is of August.
2025.
These things should be disposed of at the earliest, because this may be very vital information being sought for. How long will you take to dispose of this?
Lordship, if Lordship dispose of with the direction to consider within 60 days, we'll consider and dispose it off.
That is very simple way of doing it.
Lordship.
I want to know why, how you expedite, how are you trying to expedite the disposal?
Then I'll again have to ask.
Because why should he file a writ petition when
Yes,
the provision is there for an appeal?
Lordship, there is no time limit as such to say to dispose of a second appeal. So with
It
regard
can
to
be kept pending for ages, then?
not Lordship. What I'm trying to impress upon your Lordship is that when he comes to before this honorable court, saying that there is a violation of a legal right, that
We are not on that. We are on the question that why a delay is occasioned.
Lordship, if
How many appeals do you dispose of in a day?
in a day, Lordship, it will be around 8. What? 8.
How many are listed?
Right now, the last instruction when I received was 800 plus appeals were pending, Lordship.
Pending. And in a day, you dispose of 8.
8, Lordship. That
Closed. Closed 8.
most of them are closed because it is passed in direction to give the information or they accept the PIO's reply.
So 100 days, you will finish it off.
Lordship, 100
Working days.
Lordship, and also subject to the right now there's another 3 commissioners before. Now there are 2. One has resigned. So the other one may be retiring some point of time. It, all administration side also has to be looked into. There is no stenographer, what I know about for the matter of fact, Lordship. So all these things, though we cannot put on record, but that is.
Yes, what is your grievance?
Lordship, my RTI petition at page number 20.
Your appeal will be considered. They have filed an appeal. Appeal will be taken up. Why should we come in?
Lordship, on the last occasion when the matter was discussed before this, my line of finance submitted that the appeal was taken only the last part of the 2014. That's why this honorable board 24.
24. Now it's starting of 2025. That is correct, Lordship.
In para 6 of their reply, Lordship, it has been reflected. Page number 65.
Okay, we'll have to pass orders here now. Until and counsel for the parties registry to list this matter again on 2/4/2026. We'll try to
Yes, Lord.
streamline it.
Lordship. Highly obliged, Lordship.
Deeply obliged.
You also assist in a manner possible so that
Yes, Lord.
the institution can be
Yes, Lord.
taken up. What we can do, we'll try to do.
Many of the writ petition also have came up before the other courts, similar issue, Lordship, but we
No,
are
we understood. We understood.
obliged. Lordship.
Deeply obliged, Lordship.
I'm appearing for respondent 20.
You're for respondent number? Ms. D. Monto.
On behalf of HK Das.
नामे लिखी दिया सब D. Borman. D. C. HK, Mr. D. Monto for HK Das. Borman, Deka, Monto.
Obliged, Lordship.
May it please your lordship, I appear on behalf of the Mr. H. Buragohai Lord. I appear on behalf of the Mr. H. Buragohai. Lordship, the present review petition has been filed seeking the review of the order dated 5/1/2026.
Page, madam, page.
Page 26, lordship. Passed by the writ petition 5629 of 2025. Lordship, the opposite party submitted that his grievance had been redressed. So that's why the case was disposed of and the petition was withdrawn, lordship. But submission was incorrect and false, lordship.
Why?
Because his transfer order has not been cancelled yet.
You implement that. You implement that, madam. There is no stay order. You implement that. I'm keeping this pending. I asked that man on the petition in person. I asked that person very, very kindly why you are withdrawing. Okay. Lekha. Third, Miss
It's Burwa.
H. Burwa, Learned Counsel for the petitioner. The present application review petition has been instituted for recall of the order dated 5/1/2020 on the ground that false submissions came to be made in the matter by the petitioner in person. Also, issue notice returnable 4 weeks. Petitioner to take steps for service of notice upon the sole respondent by way of speed post. Petitioner also permitted to take to effect service of notice upon the sole respondent by way of trustee routed through the registry of this court. In the event it was like one affidavit filed to registry to list this matter again after 4 weeks. Madam, you comply with your insist on that transfer order. Let him come. We'll see.
Nice of this.
My lord, 52, I'm appearing for the respondent number 1, my lord. The order of this honorable court is complied with, my lord.
No? Order complied with?
Complied, my lord. One order passed on 15/1/2026.
Yes. Where is the compliance order?
My lord. Okay. Yes, sir. It is.
So, Mr. Bukas, so they have passed an order.
Let me see it.
Give him a copy.
My lord, my lord.
And the matriculation exam is over. So
Yeah,
nothing
over.
survives here. Mr. Heard Mr. D. Pukhasta, Learned Counsel for the petitioner, and also Mr. P. Soikia, Learned Counsel appearing for the respond number 1. Mr. Soikia has submitted that the district commission, after carrying out a verification of the premises of the petitioner school, comma, has passed a speaking order dated 15/1/2026, holding that the school could not be considered as an HSLC examination center for the academic session 25-26. He submits that the directions passed by this court wide the order dated 18/12/2025 in WPC number 7343/2025 has accordingly been complied with. This court has perused the order, speaking order dated 15/1/2026 and finds that the same has been issued in compliance with the orders, directions passed by this court, widely said order dated 18/12/2025. No willful and or deliberate violation of the directions passed by this court being found, comma, the present contempt petition stands closed. Liberty, however, is reserved to the petitioners to institute appropriate proceedings assailing the order dated 15/1/2026 and or the 15/1/2026 and or the issue in 15/1/20. Copy X. P. Soikia, copy X.
Mas
Equity.
Complaints of the last order. Today we have filed an IA for recalling of that concern order dated 17/11/25. So
Registry to list this matter again after 2 weeks, along with the interlocutory application stated to have been filed today by the Learned Counsel for the petition.
Well, I need some time. Well, I have not received any instruction.
Lordship, petitioner is a disabled person, Lordship. Your Lordship was directed to the respondent authority, Lordship, to examine the marks report by the petitioner and appointed the petitioner in Golaghat district, Lordship.
Wait. We have orders are of
Lordship, order is page number
23/4/24. How long will your people take to?
Hello, I have asked the person concerned, my lord, but I have not received because she is also in leave, my lord.
An important thing is that
Director is
Lordship,
in
petitioner
leave.
is a disabled person, physically handicapped person, Lordship.
Mr. Bora is granted a last chance to place on record the compliance report with regard to the compliance pertaining to compliance report pertaining the envisaging compliance of the directions passed by this court-wide order dated
23/4/2024.
23/4/2024 in WPC number 665/2024. 3 weeks.
Lordship, kindly date may be fixed, Lordship.
You come and mention, I'm here.
Obliged, Lordship.
My pleasure, Lordship. Service is complete, Lordship. Service is complete.
In the office note dated, Lauzima Court order dated 5/3/2026. Service upon respond number 3, 4, and 5 has been held to be completed accordingly. Registry to list this matter for admissions. After 2 weeks on a date 2, 3 weeks on a date 2 weeks.
Obliged. Wait, your Lordships. Sir, issue regarding the provincial service of the writ petitioner. The last very occasion, your Lordship, this honorable court at time and again asked this the education department.
Just the same.
Lordships. 26/11/2025.
In the office note dated 5/3/2026. Service upon respond number 3, 4 and 3, 4, 5 and 6 is held to be complete. So accordingly, raised to list this matter for admission hearing on 6/4/2024. In the meanwhile, Ms. D. Mushahari shall apprise this. PC Mushahari.
Lordship, I
D.
have
Mushahari.
placed your lordship.
She is the one.
I have placed.
Shall apprise as to the fact as to whether the proposal pertaining to the provincialization of services of the petitioner has been forwarded to the finance.
No, it is forwarded.
And
It has been.
it has come back.
Lordship.
And as to whether the approval thereto has been received.
Obliged, your lordship.
May please, your lordship. Contempt matter, my lord, we are lordship at directed for personal appearance of the respondent number 4 along with others, my lord. At the outset, my lord, I tender my apologies for not remaining present on that day. My lord, before explaining further, my lord, on what happened, my lord, may I please draw your lordship attention to annexure R1, my lord, page 12, to show the steps we have taken for compliance with the order, my lord. Page 12. This is the letter we have written immediately on receipt of the contempt notice from the court, my lord. And the reply that we receive from.
When is the date fixed?
16th, my lord. Absolutely my fault on that day, my lord. It was an error on my part, my lord, error of judgment, my lord. I was expecting the matter to reach in the second half, my lord. As informed by my learned brother, my lord, it was taken up at around 11:15 and 20. My fault, my lord. There's no contempt coming.
You underestimated this court's speed.
Definitely no, not my lord. I was waiting before court number 1, my lord, for item number 27 and 31.
Pension papers have not reached you.
The reply, your lordship will kindly peruse page 14, my lord. It seems that they will not forward, my lord. They say that the service of the person concerned was never regular.
The contempt file to some. I mean. Yes, this where is your regularization order?
I have annexed, my lord, in contempt petition.
Where?
Yes, 15. And my father's name included in page 17. Serial number 28.
Heard Mr. B. Sharma, learned counsel for the petitioner. Also heard Mr. Applicant. Also heard Mr. K.R. Padgiri, learned counsel, appearing for the contempt petitioner. Opposite party number 1 oblique contempt petition. The present application, interlocutory application, has been instituted for recall of the order dated for exempting the applicant hearing from appearing personally before this court on 16/3/2026 in the connected contempt petition in terms of the directions passed by order dated 23/2/2026 in contempt petition contempt case number 423/2025. Mr. B. Sharma, learned standing counsel, Mr. B. Sharma, learned counsel for the applicant, submits that the applicant herein is the authority of the office of the accountant. Is the accountant general?
Accountant general.
Is the accountant general A&E Assam, and is the disbursal authority of the pension and pensionary benefits. However, in the present case, the proposer for authorization of pension in respect of the petitioner in the contempt case has not been received from the administrative department, and accordingly, there has occasioned no violation of the directions passed by this court by the applicant hearing. Also, Mr. Sharma, in the above fact situation, prays that the applicant be exempted from appearing before this court on 16/3/2026. I've heard the learned counsel for the parties and perused the materials available on record. The materials brought on record having revealed that the pension proposal in respect of the pension proposal for authorization of lifetime arrears to the opposite party number 1 oblique petitioner not having been forwarded by the Public Works Road Division to the department, to the Office of the Accountant General, A&E Assam, there has not occasioned a violation of the directions passed by this court by the Accountant General, bracketed A&E Assam. Accordingly, this court exempts the applicant hearing, who is the respondent number 4 in the connected contempt petition, from appearing personally before this court on 16/3/2026. The said order of exemption is limited only to the respondent number 4 in contempt case number 423 of 2025.
Much.
My lord, matter was heard regarding the pension of casual workers. We have given 4 citations of the Honorable Supreme Court, and today, my lord, I have brought another. This is our High Court division bench order. So after 32 years, her service is not regularized. Now she is on the way to go. If after death she gets pension, what will be the benefit? State cannot track the benefits of some mistake that they had not done.
Her.
My lord. My lord is taking up this matter now, my lord, hearing.
Really not today, 5 o'clock. You can relax.
Then I will, my lord, I will just go by the affidavit, my lord.
No, affidavit you have filed already.
Ah, yes.
Affidavit filed. But affidavit cannot go the Supreme Court's order. Beyond the Supreme Court's judgment, Umadevi's judgment has been wrongly interpreted.
Trying to get it, but I've not got it. It's Yakub, 1964 or 65. Supreme Court had laid down that the single bench is bound to follow the division bench order. And even if there is a order of the Supreme Court, that will not automatically be entitled to be done. I'll have to refer the matter. 1964 or 67, trying to find that matter. If you get somewhere, just Yakub.
I will, my lord will see the, into the first, go to the facts of the case, my lord.
What is it? Tell me.
My lord, in 2000, their regularization was cancelled. Without jurisdiction, the executive engineer did it. Government recalled all the orders. 2000.
But 2005, why their cases were not considered? 2005, why their cases were not considered? She's a pre-1493 appointee. Yes, Mr.
My lord, yes.
You are a 1493, pre-1493.
Yes, my lord.
Then why the case was not considered in 2005?
I have given the judgment of 2025 of Supreme Court.
Then my lord will have to interfere with our finance OM also, everything, my lord. Because we say that, my lord, no more regularization. Everything is to go.
Jaggo, this court is bound. Can't go beyond Jaggo. I'm giving you a handle. Give me a perspective.
My lord,
one perspective for me is, both of you, 2005 regularization process. Subsequently comes 2017, the decision of Upendas, bar therein for regularization.
Further,
My lord,
section 30.
Counsel for
my lord, 2005
remains inconclusive. Registry to list this matter again. Khali dino dia. 7-4.
Long time.
1993
upgraded data.
Registry to list this matter again on ARD. 30. Matter tie up no hai? 30. Or you want it next week?
Yes, my lord.
Next week logai dia. Kumba free bench thakile tate logai dibo. Matter full ase. Belegot logai dibo. Ketia dia? 11. Ama yat nalage dia. No, belegot dibo dia. Urgency ase to.
Then it will be rather delayed the matter. I think.
Then on an 10 koi dia.
10.
10-3.
Before this bench.
No.
Then again it will delay.
That I can't help it because Mr. Mahmood, I have been fixing up matters. There was a